Wait, please, Your Lordship.
Yes.
Lordship, in respect of item number 24, we have
Hmm.
circulated the memo of adjournment yesterday. Can it be after the BU, Lordship,
For the petitioner,
for the petition?
as paid for by the learned counsel for the petitioner and not objected to by the other side. This is matter again after the ensuing revocation.
Lordship, with an interim order, let me continue.
Interim order passed earlier shall continue till the next date of listing.
Obliged, Lordship.
So item number 26, 27 and 28. With the consent of the other side, Lordship, I need some instruction in this matter from our clients. Lordship. So matter may kindly be taken up after revocation. 26, 27 and 28.
You are for the
Petitioner. And I have taken,
petitioner.
yeah, I have taken consent of the other side.
Okay, on the prayer made by the learned counsel for the petitioner and not objected to by the other side. This is the matter. Again, after the ensuing revocation. Yes.
May I please, my lord?
Obliged, Lord.
26, 27, 28.
May I please, my lord?
Yes.
Respect of item number 42 has become infructuous. I have received written instructions from my client not to pursue it any further. Item number 42, my lord.
What is your good name?
A Sandilya, my lord.
Please write item 42. Mr. A. Sandilya, learned counsel for the petitioner, submits that the matter has become infructuous and he has infructuous. Stop. In view of the above submission, the matter stands disposed of as infructuous.
Obliged.
Yes.
May I please? Lordship,
Yes.
I beg to mention item number 31, Lordship. I am for the petitioner, Lordship. And I have taken consent from the other side, Lordship. It may be taken after BU vacation, Lordship.
31.
31, Lordship. I am for the petitioner, Lordship.
Hmm. Who is for the respondent number 9?
But I have taken consent, Lordship.
From whom?
From the private respondent, Lordship.
Private respondent is respondent number 9. Is it?
Lordship.
Okay. On the request made by the learned counsel for the petitioner and not objected to by the other side, place the matter again after the ensuing BU vacation.
Obliged.
May I please, Your Lordship? With the consent of other side, I beg to mention item number 36.
36.
The matter may be adjourned for the day.
You're for the
I am for the petitioner. P. Bora.
okay. On the request made by the learned counsel for the petitioner, the matter stands passed over for the day.
After beautification.
Okay. Right like this on the request made by the learned counsel for the petitioner and not objected to by the other side. List this matter again after the ensuing BU vacation.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 5. I have taken the consent of the other side, central bank. Lordship will need to file an implement petition, including the private respondents. So let the matter come after BU vacation.
You're for the
I am for the petitioner's, Lordship.
yes. What do you want?
I want some time to file an implement petition, including the private respondents.
Private respondent. Why?
Lordship, because there is a select list wherein our names do not find, Lordship. We do not find our names. So we have to file an implement petition.
Implement is required.
Lordship.
You're aspiring to become Safai Karamchari
Yes, Lordship.
in the central bank.
Central Bank, Lordship.
Learned counsel for the petitioner prays for how much time? 2 weeks
4
time.
weeks, Lordship.
4 weeks time to file application for implement of private respondents. Prayers allowed. List again after 4 weeks. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 19.
Item number
19.
19.
I pray for Your Lordship to kindly adjourn the matter for the day.
You're for the
Petitioner. Lordship, I'm
The-
appearing on behalf of Mr. P. Mantha.
Imanta.
Yes, sir.
Counter has not been filed, isn't it?
Yes, sir. Lordship.
On the request made by the learned counsel for the petitioners, matter stands adjourned to be listed again after the ensuing BU vacation. Respondents to file their counter affidavit in the meantime. All right.
May I please, your lordship, back to mention item number 43, madam. In this matter, my lord, I am praying for some accommodation for today itself, madam.
You are praying for?
I am praying for some accommodation, my lord, for today only.
Anganwadi worker.
Yes, madam.
There's no counter also. Counsel for the petitioner. Praise for. No, you cancel that. On the request made by the learned counsel for the petitioner, the matter stands adjourned for
For today, madam.
the day.
Yes, madam. Obliged, madam.
Item 43. Okay.
May I please use your lordship.
Yeah.
Your lordship, I beg to mention item number 38 of the daily list, lordship.
Number
38, lordship.
38.
Yes, lordship. I'm praying for withdrawal, lordship, as it has become infructuous, lordship.
What is your good name?
J. Lotha, lordship.
Mr. J. Lotha, learned counsel for the petitioner, submits that the matter has become infructuous.
Infructuous, lordship.
In view of above submission, the writ petition is disposed of as infructuous. Interim order passed earlier stands vacated.
Highly blessed, lordship.
Yes.
Lordship, I appear for the government, your lordship.
Mr.
D. Bora.
D. Bora, learned government advocate, appears for the state respondents.
May it please your lordship.
Yes.
Lordship, I beg to, with the consent of the other side, I beg to mention item number 51, your lordship.
51.
51, your lordship.
Yes.
Your lordship, service is complete for the private respondent. The matter may be fixed for admission, your lordship. I've taken consent from the other side.
As submitted by the learned counsel for the petitioner, and as per the office note, notice is served upon respondent number 6, and therefore the same is declared to be complete. Stop as prayed for list the matter for admission after 2 weeks. Sorry.
Deeply obliged, lordship. Yes. Good morning.
Good morning, my lordship.
Yes. You're not interested in this case?
Already, petitioner is getting nervous because the petitioner is depriving again and again from the authority. Because two times from the Agricultural University Jorhat appointed him as chief scientist.
Okay, that is on the merits. This is listed for orders under the column no steps. So, court had directed you in the month of March last year, 27 March 2024,
Yes, my lord. So I have
to take
already-
steps on
already-
respondent number 6.
Yes, my lord.
When are you going to take steps?
I have taken my lord.
When? When did you take steps?
So sorry, my lordship. Yesterday, my lordship.
Yesterday. Okay,
Actually.
are you sure? Are you sure? Please write down office note dated 26/3/2025 indicates that petitioner has not taken steps for service of notice upon respondent number 6. Stop. However, the learned counsel for the petitioner today submits that she has taken steps yesterday and produces an acknowledgement slip. Stop. In view of above, please the matter again after 2 weeks to await service report from respondent number 6. Okay,
Thank you, madam.
we take back this.
May I please, your lordship, my lord, I apologize, you could not take step in time, your lordship, so 2 days time may be allowed, I will take steps, your lordship.
In time means what? 1 year.
No, 2 days time.
Order was passed 1 year back.
To give
You
some
should pay
answer.
some cost. How much cost you will pay?
In fact, I have doubt, my lord, extra copy
No,
also not served, I think.
But one thing, Respondent number two is official respondent. That is the Secretary Finance.
Yes,
There are no government advocates to receive notice for Finance Department or Standing Council Finance Department. Who is the Standing Council?
My lord, numbers of consists are there, my lord, including P Nayak is there, my lord.
P. Nayak.
They can directly serve, my lord.
Why don't you serve to the Finance
I will
Finance
serve.
Department Standing Council?
Some unavoidable circumstance could not serve. I will serve your lordship.
No, no. Okay, you'll serve now, no problem. We'll allow you to serve that. But in the first place, when the matter was listed on 29th of April 2024, you should have informed the court. Number two is a finance department. I will serve copy to the standing council. As easy as that. You should have said that. Please write down. This matter has been listed under the column open inverted comma order no steps. In view of the fact that the petitioner has not taken steps for service of notice upon respondent number two. Stop. It is seen that respondent number two is the Secretary to the Government of Assam Finance Department. Stop. In view of above, petitioner is allowed to serve notice to respondent number two through the Standing Council Finance Department within 3 days and shall obtain an acknowledgement receipt which should thereafter be submitted to the registry as proof of service. List the matter again after 2 weeks.
My lord, lordship may direct also to serve the extra copies to the earlier.
Petitioner shall also serve extra copy of the writ petition to Mr.
S. Datta.
S. Datta, learned
Standing Council PNRD.
Standing Council, PNRD Department, within 2 working days.
Always.
Yes. You are there?
Lordship, I am for respondent APSC, Lordship.
What has happened to this case?
Lordship, the entire case record was seized, Lordship. 2013 CCA exam, Lordship.
Entire case report seized.
The entire selection process records were seized. Lordship.
Okay, then
Lordship, Justice BP Kotoki, Justice BK Sharma sir has, commission has submitted his report also.
what has happened to that report?
Lordship,
Any
that,
action taken
Lordship, that is also under challenge.
under
I-
challenge? Okay, that apart, what about the counsel for the petitioner?
Lordship, as per our instruction, Lordship, no parawise comment could be received because of,
Again, you're talking about yourself. I'm asking you about the petitioner. Because
Lordship.
from the records, I see that so many times they have not appeared,
Lordship.
isn't it? Who's the counsel for the petitioner? 47.
Mr. G. Chaudhary is appearing, Lordship.
The Lavazima court's order is there,
Lordship.
25-3, 25-3, then 12-3, 12-3, then 20-12, 24. Every time no one appears. Please write down, none appears for the petitioner when the matter is called. However, Miss
P. Sharma on behalf of Mr. T.J. Mahanta, Lordship.
P. Sharma, learned counsel, appears on behalf of Mr. T.J. Manta, Standing
Standing
Counsel, APSC.
Lordship, kindly pass over for, kindly time being pass over for time being, Lordship.
Why?
Engage counsel is foot number 19, Lordship.
Why didn't you appear before the Lavazima court? Many times it was listed. You were asked to obtain the address of respondent number 6.
Lordship, kindly give some more time, Lordship. Kindly give us a 1 week time, Lordship.
1 week time for what?
So collect the proper address, Lordship, of respondent number 6, Lordship.
Stop. Later on, Miss, your good name?
And Kolita.
N. Kolita, learned counsel, appears for the petitioner and prays for 1 week time to obtain the correct and proper address of respondent number 6. To stop. It is seen that the petitioner has failed to appear either personally or through his counsel before the Lavazima court on various occasions. Stop. However, as the learned counsel appearing today for the petitioner seeks 1 week time to do the needful, the prayer is allowed. Stop. The counsel for the petitioner within 7 days from today shall submit the correct and proper address of respondent number 6 and take appropriate steps for service of notice upon the said respondent. List the matter again after 3 weeks.
Next.
May his lordship.
Yes.
My lord, my senior R. Mazumdar, he is newly engaged in this matter. I pray that this matter may be adjourned for the day.
R. Majumdar.
My lord, he is newly engaged in this matter.
Has he filed his power?
My lord,
Has he filed his power?
not yet, my lord. We are.
When will you file the power?
We will be filing this today, my lord.
During the course of the day? Today?
We'll be filing today, our Bagaatama.
Today you'll be filing. Okay. You are for the
My lord, I am appearing on behalf of Mr. K. Kaur, my lord. He's in another court, my lord. His name may be recorded. Additional
Kaur.
Advocate General K. Kaur, my lord.
cake war.
He's
He appears
appearing
for
in
whom? He appears for whom?
for the state, my lord.
For the state.
Right.
What about the forest?
All the state, my lord.
All the respondents.
Yes. Government, respondent.
So forest has already filed their affidavit. Only
Right.
respondent number 2 has filed affidavit.
My lord, the Standing Council of Forest can assist him, my lord, but additional AG can appear for the statement. Mainly for the government, my lord. But Standing Council Forest will assist him. My lord.
Miss T. Wapangla, learned counsel, submits that Mr. R. Majumdar has been newly engaged in the matter by the petitioner and therefore prays for
For a week time.
a week's time to prepare the matter. To stop, she submits that the Vakalatama to appear on behalf of the petitioner will be filed during the course of the day. In view of above, list this matter again after a week.
My lord, a date may be fixed after vacation, my lord, if possible. After being vacation.
Okay, in view of above, list this matter again after the ensuing Bihu vacation on a date to be fixed by the registry. Anything else?
My lord, Mr. K. Kaur's name may be recorded, my lord.
Mr. K. Kuar, Learned Additional Advocate General,
Yes.
Assam, appears for this respondents,
My-
state respondents.
My lord.
Anything else to be said?
My
Ms.
lord,
Wapangla,
my lord, a fixed date may be given, my lord.
why?
My lord, yes.
Hmm? I've already indicated.
It will
notified
come.
by the
madam.
registry.
Yes, ma'am, it will come. madam.
Apply.
Highly obliged. ma'am.
Yes. No one. None appears for the petitioner when the matter is called. However, Mr. D. Bora, learned government advocate, appears for the respondent number 3. It is also seen that the LCR has come. LCR has come from where? PG case. What is this PG case?
Basically, it's to pension gratuity or those payments from Coal India. Now, there is a dispute with regards to that, therefore, the petitioner has not been paid.
Somebody has gone to the PG. What is this PG?
PG.
Subdivisional magistrate,
Subdivision magistrate,
Margarita. PG case number 1 of 2021.
payment of gratuity. Whereas the LCR is on record.
Okay, you seen that the LC has come back, come from the uh, subdivisional magistrate, bracket executive magistrate, Margarita. Now, since the petitioner is not present today, let the matter is adjourned for 2 weeks. Just a minute, one more. Office note, no. Lavasima Court's order dated 3/12/2024 indicates that notice has been effected upon respondent numbers 4 to 7 by the officer in charge, Lekapani Police Station. Stop, upon perusal of the same, notice is accepted to be complete. Stop, however, as no one appears for the petitioner as well as the private respondents, matter stands adjourned for 2 weeks. Chairman Mayor of the line. 52. Again, no one. None appears for the petitioner when the matter is called. Office, no. Lavazima Court's order dated 23/2025 indicates that upon tracking the postal consignment of the notice sent to the respondent number 6, it is found out that the same has been delivered. Stop. As such, notice is accepted to be complete on respondent number 6. Stop. However, as no one appears for respondent number 6, nor the petitioner, the matter stands adjourned for 2 weeks.
Lordship, I appear for 4 and 5.
Mr. D. Bora, learned government advocate, appears for respondent numbers 4 and 5.
May I please the Lord? Service in terms of, in respect of respondent number 8 has been completed
Okay.
as per the office note, Lavazima Court order dated 26/3/25. That is be fixed for admission hearing also.
Parties are represented by the respective councils except for respondent number 8. Lavazima Court's order dated 26/3/2025 indicates that postal consignment of the notice sent to respondent number 8 has been delivered. Stop. Accordingly, notice on respondent number 8 is accepted to be complete. Stop. Since no one appears for the respondent number 8, matter stands adjourned for 2 weeks. Registry to list the matter in the admission column after 2 weeks.
Kindly fix a date, Lordship.
On 2 weeks, give a date.
Much appreciated.
All right.
22 April.
My pleasure, my lord, this case relates to the condemnation of delay, my lord, against the ex parte order, my lord. We are seeking the review, my lord. There was a delay of 663 days, my lord. To that effect, my lord, I have engaged my counsel to defend my case. He did not appear, my lord, for which it subjected to a affair in my native place against that lawyer, my lord.
Who is for the respondent?
I have received an affidavit opposition today, my lord.
Filed by?
Filed by the respondent number 5.
Number 5.
Number 5 is the
Who-
writ petition.
Who is the counsel?
Counsel, my lord, causeless has been shown, my lord, some Kalita,
NK Kolita.
my lord.
He has not come?
We give it to ICN. All lordship can call for the affidavit opposition filed by the respondent number 5, my lord, and fix the matter on 7th.
7th.
Nothing even. All lordship is not available then on Friday.
Not available.
Then on Friday, my lord.
Friday.
Friday. We'll make an effort, my lord.
Mr. J.I. Borbuya, learned counsel, appears for the petitioner, stroke applicant, stroke applicant, and submits that he has received a copy of the objection filed by the respondent stroke writ petitioner to the IA. However, no one appears for the respondent stroke writ petitioner, although the name of Mr. N.K. Kalita, learned counsel, is shown in the cost list. Registry shall verify as to whether the affidavit, as to whether the objection to the IA has been filed by the respondent stroke writ petitioner. And if the same is filed, the affidavit, the objection be connected to the case record. List this matter on Friday. What is the date?
4th.
On 4th of April 2025. As prayed for.
May please, Your Honor.
Yes,
Please, your lordship.
yes.
It relates to non-payment of retirement benefits of the petitioner, lordship,
Ah.
who retired from service on 31st of March 2016, lordship. She was serving as a sales girl in the Assam Khadi and Village Industries Board, lordship. There is no provision for pension in the board, lordship, only retirement benefit, gratuity, CPF and leave salary. Since 2016 till today, lordship, I have not received my retirement benefit, lordship. In fact, they have calculated my retirement benefit, lordship, on 2/4/2024, lordship. And that was submitted before this honorable court, lordship.
Hmm.
Also,
Then what has happened?
thereafter, nothing, lordship. Since 2016, lordship, I have not received any benefits, lordship.
What was the petitioner working as?
As sales girls, lordship, in Khadi, in Assam Khadi and Village
Sales
Industries.
girls
Yes,
in
lordship.
Assam Khadi Village Industries Board.
Yes.
No pension is permissible.
No, no, there is no provision for
What,
pension.
what is given then?
Only gratuity, contributory provident fund and leave salary.
Okay.
And
this
they have
amount-
already calculated, lordship,
The amount which is due, this is towards
towards all, lordship, leave salary, gratuity.
those three components, gratuity, leave salary and
Yes, and a leave salary and gratuity and CPF, contributory provident.
CPF.
Yes,
Okay.
and they have calculated in the year 2024, lordship. 18,19,169. That was the calculation, lordship.
But who is appearing for the Khadi
Yes.
village?
What happened, my lord, there was some misappropriation on her part, my lord, though departmental proceeding was not initiated, my lord. Because of that, my lord, the amount was not released at that moment of time, my lord. My lord, will kindly come to page 32 of the affidavit filed by Handloom, my lord.
32.
32. Respondent number 2.
It's one number 2.
Respondent number 2, my lord.
Number one.
Respondent number 1, my lord.
One. Filed on, I think, 31st May 2022. 31/5/2022.
That was filed on 31st May 2024, my lord.
Respondent number 3 is there. One also has filed.
One has filed, my lord. That was on 31/5/2024.
Oh, yes.
Page 32, my lord.
Page 32.
32.
Yes.
But as my lord, the Khadi board, my lord, relies on the grants in aid provided by the government, my lord. Parent department is handloom and textile, my lord. And as because there was some misappropriation on her part, on the part of the petitioner, my lord, the amount was not released at that moment of time. And due to and another amount was sanctioned, my lord, which was given to the retired employees, my lord. So we made a proposal, supplementary budget proposal to the government, my lord, to release the amount. That is the letter, my lord. I'm trying to
What letter?
at page 32, my lord. That is the proposal.
32 is not a letter. This is a paragraph. Paragraph 2-3.
32, my lord.
32. 32 of the affidavit filed by the respondent number 1. lordship.
Correct. Page 32 is something else in my copy. Show it. Show it. Page 32. देखो क्या
Letter dated 22/4/2024.
See page 32. Yours is 32 years 43.
That is how it is.
Why? Why?
That is how
why
it
is
has
happening
been
like
furnished to us, madam.
This is not the first case. In other cases I've seen, pagination is not tallying.
Probably, my lord, because nowadays there is a running, the pages are numbered in a running way, but this way may not be good.
So how do you keep track of the running pages then?
That is becoming a very difficult one, because at
Yes.
the time, 2-3 affidavits comes in line.
Ah.
Suppose respondent 1 is filing an affidavit, he takes the confirmation number from the last page of the writ petition.
Correct.
In the same time, another respondent is filing, he also takes it from the, so my lord, That is why my lord is not telling, that is the problem. But when actually, this is what registry they do it. Once we file it, registry they correct it. It was the my lord initially.
So you have to keep track of that.
Yes.
Because if you go by your own pagination, then we'll not be reading together.
That is been corrected by the registry and we are not privy to that. That is why.
See, somebody has to do the
Yes,
correction.
yes, some,
And somebody has to come and check here also, whether it's tallying or not, before the matter is called out, so that.
Our file, Lordship.
Ah,
You have to check.
okay, page 43, what is
43,
this?
my lord. That is the letter we have sent to the government. My lord,
Ah,
handlooms.
then,
For the
this was in April last year.
Yes. Now they have filed the affidavit, my lord, the government, my lord,
Hmm.
and they are saying that.
You're for handloom,
No, no. My
you're
lord,
for khadi,
Khadi, my lord,
you're for khadi.
Khadi. So we sent a proposal for supplementary to be placed in the in the budget session, my lord.
Hmm.
But that was not done. They have taken it from that would have been placed before the monsoon session in the month of August to September, my lord.
When? This year, August?
2024, but that was.
Oh, last year.
Paragraph
Then,
9, they have stated, Lordship.
then what happened?
That is what my friend will say.
Mr. Dhar,
I look, here the thing is that we are not responsible for the, my lord, Khadi's employees. We just give grant in it. That is what we stated in our affidavit, my lord. Those are the facts that they have sent us a letter, my lord. That is what we stated. But my lord, it is their primary responsibility, my lord, that they have to pay. We just, my lord, as a whole, we give a grant in aid to them. But paying salary, everything, my lord, they do misappropriation. This is not our, my lord. Look out, my lord. They have to mandate, my lord, because it's an independent board, autonomous body. They have to run it, my lord. They misappropriate and then, my lord, they fall short of cash. They just cannot push it to the government, my lord. Because we don't take anything from, when they do profit, my lord, government doesn't take anything from them. It's not a profit organization. Hollywood is not a profit organization. My lord.
it may be like that, but the thing is that person is demanding this money, which is due to him.
We give it
Last-
Gratuity,
Almost 10 years.
gratuity, leave salary, and that
from budget that
the EPF.
that has been allocated to us, my lord.
Hmm.
The budget that has been allocated. But that letter, what I'm trying to place it before Lordship, my lord. That letter says, my lord, the amount which has been given for the retirement benefit of the petitioner, my lord, that amount has been, could not be given due to some misappropriation, and that amount was given to other retired employees. That letter says, my lord.
What misappropriation?
No departmental proceeding was initiated, Lordship, for misappropriation.
Simply saying misappropriation will not do unless you take some action. You can make a lot of allegations, this, that. But unless you take the,
We will pay it, my lord.
when will you pay it?
That is what, my lord, the proposal we have sent, my lord. And they say at paragraph 9 that will be placed in the budget session of August 2024. Now, whether that has been placed or not. My lord, para 10, we have taken a categorical stand, my lord. What the Supreme Court has laid down the law, my lord. There was the case once, my lord. The High Court held that, the single bench held that PSU, my lord, the government has to pay to some corporation. Division bench held. We went to the state, went to Supreme Court, and Supreme Court has laid down the law, my lord. That is what we have stated in para 10.
Para 10 of which affidavit?
Of our affidavit, my lord.
Of number one, respondent number one.
One, my lord. Para 10, my lord. The deponent further begs to state that in a similar situated case, the Honorable Supreme Court of India had held in para 11, 12, and 13 in state of Assam versus Barak Upatyaka DU Karmachari Sanstha, reported in 2009-3 Supreme 2008. That is what, my lord, wherein it's category held that. Next page, my lord, in 11. What clearly holds the field at present is that is the principle laid down and reiterated by the Constitution Bench of this Court in Steel Authority of India versus National Union Waterfront Workers such and such, wherein court categorically held. We wish to clear the air that the principle while discharging public functions and duties, the government, companies, corporations, societies, which are instrumentalities or agencies of the government must be subjected to the same limitations in the field of public law, constitutional or administrative law, as the government itself does not lead to the inference that they become agent of the center state government for all purpose, so as to bind such government for all their acts, liabilities, and obligations under various central and or state acts under private law. We therefore reject the interpretation put forth by the respondent on the tentative observation in Kapila Hingorina 1 and 2 to contend that the government would be liable for payment of salaries and other dues of the employees of a public sector undertaking. We are of the considered view that the decision of the High Court cannot therefore be sustained. That was, my lord, that was the view of our High Court, my lord. The Supreme Court has interpreted. We accordingly allow the appeal, set aside the order of the division bench and the learned single judge of the High Court, and dismiss the writ petition without prejudice to the right of the employees of the commune to take such actions as is available in law for the redressal of their grievances. We may also add that this decision will not come in the way of state government formulating any schemes or extending any relief or benefit to the employees of commune or other similar civil persons. Meaning thereby, my lord, the state is not responsible for, my lord, this such corporations, my lord, to pay their salaries.
Okay. You made your point, but what about this letter? Pursuant to this letter,
Yes.
what steps have been taken? You're not going to give the fund, or what is your stand?
My lord, we stated
This is your affidavit, isn't it?
yes,
Number one.
my lord, yes, my affidavit.
Now you have annexed this as annexure B. Annexure B.
My lord, this para 9, my lord. There we stated two things, my lord. One, we stated we will place it before the assembly, my lord. And second is, my lord, the second paragraph in the next page, my lord.
Where, which paragraph?
Para 9, my lord.
Para 9.
Para 9, my lord. Para 9, there is again sub-para, first, second, third, fourth para, my lord. The next page. The Assam Khadi Village Industries, my lord.
Yes.
The Assam Khadi and Village Industries Board is primarily responsible for payment of all dues, benefits, including retire benefits to its employees as stated above in para 3, 4 and 5 of this affidavit. The government in Handloom Textile Department has continuously supported the board with financial grants. That is what I stated, grants in aid. As shown above in para 6 of this affidavit, Assam Khadi and Village Industries Board may perhaps take steps to pay the retirement dues to the petitioner from their available board's fund. My lord, we cannot give money in the name of salary benefits to particular person. We just can give grant in aid. We provide them a grant in aid, a lump sum amount, my lord. That is, they have to utilize. How they utilize it, my lord, that is their lookout. Because we do not interfere in their day-to-day activities.
Your affidavit was filed in June.
My lord, it was 1/6/24.
June 24. And in the paragraph just before you read, there's also a statement which says that it
Yes,
was
my lord.
to be placed before the, what is that?
General budget, my lord. My lord, I don't have any instruction after that what happened.
Next monsoon session
My
of
lord.
Assam Legislative Assembly, which will be in the month of July or August.
My lord, after that, I don't have any instruction. What happened to this? Maybe they have got grant in aid, because obvious, every year we provide grant in aid, but we never give money in the name of this head that you will pay salaries to this person. That is not our lookout, my lord. We will just we provide year to year, or maybe in 2 years, we provide grant in aid,
All right. So supplementary demand was placed before the assembly.
my lord.
What has happened there? That you tell us.
My lord, on the next date, my lord.
And how much funds you have received? Grant in aid.
For this purpose, we have not received, madam.
For this purpose you have received, you had paid somebody else.
Yes, sir, at that point of
Okay.
time, yes.
Now for other purpose you receive, you pay the petitioner now.
That is what, my lord.
Why you are managing like that?
Because, my
This
lord,
money you'll give there, that
because-
money you'll give here.
Because, my lord, we will not pay giving money and you then The first thing is that these writ petitioner, they are the 44 lakhs misappropriation. They did not do anything during her service. No steps was taken. Now they come for money mallet. If they cannot handle this ballot, we are not ballot duty bound. And Supreme Court is very clear on this ballot.
It's not that, my lord, the parent department have never issued, given money, my lord, in that way, my lord.
All right, see,
They have given, my lord.
see,
I
you take instructions. I'll give you some time. How much money you have received as grant in aid? And Mr. Dhara also will obtain instructions as to what happened to that session,
I will.
whether anything
I will
happened
do
or not.
I will.
So, please write, parties are represented by the respective councils. It is the case of the petitioner that he or she has not received her retirement benefits in full till date, which has prompted her to file the instant writ petition. To stop on 3/4/2024, on the submission made by the Learned Standing Council, Assam Khadi Village Industries Board, that a total amount of rupees 18,19,169 has been calculated to be payable as retirement benefit to the petitioner in terms of communication dated 2/4/2024. And that the amount and that a supplementary demand proposal was going to be placed before the appropriate department of the government by the board for sanction of the said amount. To stop, however, as per the Learned Counsel for the petitioner, the amount has not been paid till date. To stop, the respondent number 1 has filed an affidavit on 1/6/2024, wherein at paragraph number 9 of the said affidavit, it has been stated that the supplementary demand was placed in the State Legislative Assembly on 5/2/2024 and general budget for financial year 2024-2025 on 12/2/2024. Full stop. The supplementary demand can only be considered in the coming monsoon session of the Assembly, which was due in the month of July or August 2024. So, Mr. R. Dhar, Learned Counsel appearing for the
One. Respondent 1, my lord.
respondent number 1 submits that what is this name of this board?
Assam Khadi.
Assam Khadi and Village Industries Board receives granting aid from the state government, and how they utilize the state fund is entirely up to them. To stop, he submits that the Handloom, Textiles and Sericulture Department has no responsibility in granting fund towards the retirement benefit of the employees of the board. So on the other hand, learned counsel for the board, bracket respondent numbers 3 and 4, submits that the board is entirely dependent upon the fund received from the state government. And unless the fund is received, payment of the retirement dues of the petitioner will not be possible. Next para, in view of the above submissions, learned counsel appearing for respondent numbers 3 and 4 shall obtain instructions as to how much granting aid has been received by the board during the financial year 24-25, 2024-2025. And Mr. R. Dhar, learned counsel for the respondent number 1, shall also obtain instructions as to what had transpired as to what had happened to the supplementary demand, which was to be laid in the assembly session, in the monsoon session of the state assembly in the month of July or of July/August 2024. So to enable the learned counsels obtain the respective instructions. How much time? 2 weeks. 2 weeks time is granted. List this matter again on just after Bihu.
Yes, Lordship.
When 25th, Malik?
Friday,
Friday, Malik.
on 25th of April 2025.
Obliged, Lordship.
Yes,
This petition has appeared for combined police, state level police recruitment board for the post of constable in unarmed branch district executive force, special branch APR of fire emergency SDRF Delhi police. Petitioner was qualified in the written examination. And state level board has selected him for the said post. Lordship, can you see page 39?
just a minute. Jawahar Matiwa. Page number
39.
39.
After completion of required formalities, type copy. As approved by Siam state level, you are selected, appointed temporary constable, wireless APR, police verification, medical fitness one. Only they said that after police verification, medical report.
Just a minute. This page number 39, what is this?
Appointment letter.
Appointment letter.
Appointment as constable.
in favor of petitioner.
petitioner
He was appointed.
appointed, need to, in person say advertisement and.
Then what is
Only
your
the
remarks?
question is subject to certificate police verification, medical fitness report from the competent authority. Accordingly, he reported before the APRO school, Jalukbari, for interview. Interview calling the all original passport certificate during officer 29/11. On that, he appeared in the APRO, and then the APRO has said that you are not qualified because you are not having the stream of science as per the education qualification for the same.
Let us go to the advertisement first.
Advertisement is clear. Look.
Where is that?
19th page C, education qualification.
19,
19, page 19.
page 19. Yes, which part?
C,
C.
bottom class.
Please read.
Education qualification HS and class 2, class 11, 12 pass from a recognized in a board and or country in case of can applying for post of fireman, emergency, rescue and fire and emergency service. He should have passed HS or class 12 in science stream. However, can applying for post consul whereas WOWT APRO, he or she should pass the HS class 12 in science stream. This is the he has not appeared for only that APRO, he has appeared for only posts, but he was selected in APRO. He appeared for district executive for special branch, Assam Police Radio Organization Fire Emergency Service. The qualification is, in case of this organization, there should be 12 in science.
Yes, fireman, emergency rescuer,
Yes, all the science.
science stream.
Science stream. But common examination was there for constable in district executive force, special force, Assam Police Radio, Fire, SDRF, and Delhi Police. Delhi Police still. But he was selected in APRO.
You are selected in APRO.
APRO. But
Science
this
stream is not required.
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 Required. That is the
No, if it's required, then
mistake on the part of the respondent. Was selected and he was after thorough verification and document verification, when the written examination was there, the document was verified by the authority. And then he was selected and all other things, formalities were completed. Then last occasion, they said that your qualification is not as per the norms. This is the case. My lord, if he is not.
So what is wrong in that?
My lord,
If you are to be selected for constable MPRO or fireman, emergency rescuer, you are supposed to be from the science stream.
Sir, the other.
And if it was not detected at the relevant time, they have detected later on.
My lord, other posts, there is no norms that he should be a science graduate. And he may be accommodating other posts also, my
What
lord.
is the other post?
In district executive force, special branch, these are the other posts. District executive force,
Now, how are you supposed to apply for this post?
a common examination,
Common exam.
common exam.
No, exam is
Cross-
common, but
Common.
on your application, how you have to apply? You have to apply online or by
Online, for common.
online?
Category. So
No.
kindly see page
See,
18.
see, for a particular post, some particular qualification is required. It is not that general, everybody can apply, everybody will get it.
But I have
For
applied
this stream, for this
common,
post,
yes.
science stream is required. For this post, any general category is
general
okay.
category is required.
So
Other posts,
in your application, did you not specify that you have applied for this general post?
not, same.
Then,
All posts I have applied. But they have selected me in APRO.
so they have wrongly selected you.
Wrongly say, but,
When the requirement is science stream, then
yeah.
if you have
But the
been,
other posts are available.
Huh?
They should consider me on the other posts also.
yes, what do you say?
Your lordship peruses through affidavit with regards to the other posts. Otherwise he is not eligible because he is from the arts stream. Now, if your lordship peruses through
No,
affidavit.
is there no post for the art stream?
with regards to their post, but he has not attained the requisite number of cutoff marks which is required. If your lordship peruses to just of affidavit at paragraph number 7 with regards to his accommodation in other posts,
Page number.
page number 3, affidavit filed by respondent number 2, paragraph number 7, bottom.
It is difficult to dig out the affidavit.
Please.
Every time some
Landing
page
page
number is
is
given
44.
and we turn some other page.
Landing page is 44.
I'm talking about the internal page here. In my affidavit, there is no
At that 11 time, there is
It's
no landing
difficult to
page.
see.
page actually.
It will be 44, 44.
Affidavit filed by respondent number
2.
2. Paragraph number
7.
7.
Second last paragraph.
Yes.
I'll just read out. The petitioner was selected on the basis of false information furnished in the online application. He had applied for the post of constable, APRO, FNES, and SDRF, also for which he was not eligible to apply. On the basis of the selection, the Associate APRO Training School, Jalbari, Guwahati, to complete pre-appointment formalities and verification of original documents. During documents verification, it came to notice that he had passed Class 12 examination in art stream. Accordingly, he was rejected for appointment as constable in APRO. Further, the petitioner belongs to the OBC and he could not be considered for selection in DEF, SB, and Delhi Police against OBC category as his aggregate marks were less than the last candidate selected against OBC male. The petitioner secured in aggregate 50.26 marks, whereas the marks secured by the last candidate selected against different categories in Kamrup Rural for DEF, SB, and Delhi Police are as under. If your lordship goes to next page in the table under the heading OBC category, the last selected candidate's marks was 57.66 under OBC category, and he obtained 50.26. So he cannot be accommodated in other posts also.
He has obtained 50.
50.26.
50.26.
The last OBC, MOBC got 57.66. Now, what is the scheme of the test or the scheme of the recruitment exams?
First written examination, then interview.
Written and interview. Written, he got through.
He got through interview also.
Interview got through. But
Then
at the time of checking the
verification,
of the documents, it turned out to be an arts.
he could not produce those documents because it came to be that he
he
from
is
the
a
art
art
stream. Your lordship. They found out that he is from the art stream. That is the difficulty.
That's why my question was, at the time of application, how do you apply? Is there not a separate format for the science stream posts and a
Lordship,
separate thing for the
in
science
the-
stream?
In the
Art stream.
advertisement, your lordship,
Because your statement says that he applied for the post of constable APRO.
no, he applied in a affidavit at page number 2, paragraph number 6, last paragraph. The petitioner had submitted online application preferring, he gave the preference as APRO, Delhi Police Special Branch, Fire and Emergency Service, SDRF, Emergency Rescue, and District Executive Force, DEF. He was selected for the post of constable against APRO on the basis of submission of online application. And the copy of the online application of the petitioner is Annexure B, Lordship, which is at page number 23, internal page 23.
Running page is 68.
How many paginations are there? I don't know. Some have been struck off.
That struck off is not 23, Your Lordship. The internal pages, Annexure B. At that point of time, there is no concept of running page, Your Lordship. That's why
Post applied for.
Annexure B.
Annexure B.
First preference, second preference.
First
third preference.
application details.
Okay.
So he gave the first preference as APRO, then Delhi Police, then Special Branch, FNS, FES, SDRF, then DEF.
So all these posts are meant for the science stream.
No,
not all. Not all.
Which are the ones?
As per the advertisement, Your Lordship.
Which are the ones? Which are the ones which is applicable to each case?
Important aspect, Your Lordship. His answer under the heading education qualification have you passed HS or class 12 in science stream with physics, chemistry, and mathematics? He has clicked as yes. That is why this had happened.
But he's bright, isn't it? He is bright otherwise.
He tried otherwise, but he is from the art stream, Your Lordship.
He is bright.
He is bright.
He passed the exams. He went through the interview also, although he's from the art stream.
Art stream. That is why the whole anomaly arose, Your Lordship. Because here, have you passed HS of class 12 in science stream? He has clicked as yes.
Okay, amongst these posts which has been given as preferences, which are the posts meant for the art stream?
For the art stream, Your Lordship,
DF
DF,
and the SRDF also, SDRF also.
yes. In fact, we have stated in a affidavit at paragraph number 7 itself, DF, SB, and Delhi Police. Against the only those three
Special branch
categories,
also.
special branch and Delhi Police.
And
Only
district executive
those
force.
three,
Delhi Police Special Branch, then
DF,
DF.
District
These are the
executive force.
only
these are
those three.
these are the three branches
Arts.
for arts. And you say that even if you go by that also, his score is that much.
Yes, the last cutoff marks
Uh-huh.
for OBC category is 57.66. So he did not score that much, the cutoff.
So that is the difficulty.
And he himself has stated, is falsely stated at page number 23 that he has passed the class 12 board in science.
Probably is inadvertently he has stated probably, I don't.
That is what.
So I don't think there's any case.
It's up to consider.
Okay, Art Mr.
A. Ahmed.
A. Ahmed, Learned Counsel for the petitioner. And Mr. D. Bora, Learned Government Advocate for the state respondents. Stop having regard to the projection made by the petitioner. The writ petition is taken up for disposal at the admission stage itself. Stop next, but it is the case of the petitioner that he responded to an advertisement floated by the respondent authorities concerned for recruitment to the post of constable, Anam branch, in the Assam Police for the year 2015.
Year 2015.
Stop. The petitioner was declared selected in the written test as well as in the interview. But when he was called for producing his documents and testimonials for verification by the authorities, what is the terminology? He was rejected.
His candidature was cancelled.
His candidature was cancelled on the ground that he was not from the science stream.
Norms not fulfilled probably.
As was required. In order to be selected for the post of constable, APRO, and fire and emergency services, amongst others. Stop. The learned counsel for the petitioner submits that there are various posts available which can be in which the petitioner can be considered for his appointment, since he belongs to the art stream. Such as Delhi Police, Special Branch, or the District Executive Force. Stop. Since the petitioner was successful in the written test as well as in the interview, the respondent authorities should be directed to consider him against appropriate posts as per his qualification. Next para, Mr. Deep Bora, learned government advocate, on the other hand, submits that the petitioner applied for the post of Constable Annam branch by giving 6 preferences. Stop. The first preference was for the Assam Police Radio Organization, the second was Delhi Police, the third was Special Branch, the fourth was Fire and Emergency Services, the fifth was SDRF bracket Emergency Rescuer, and the sixth was District Executive Force. Stop. The learned counsel, by referring to the statements made in paragraph number 7 of the counter affidavit filed by the respondent number 2 on 7/2/2019, submits that the petitioner belongs to the OBC category. And even if he is to be considered against the posts which can be manned by a person having arts qualification, the petitioner will have to be considered against the post meant for OBC category. Stop. He submits that the petitioner secured aggregate score of 50.26 marks, whereas the marks secured by the last candidate under the OBC/MOBC category was 57.66. And therefore, the petitioner cannot be adjusted against other posts as claimed by him. Stop. Referring to the online application submitted by the petitioner annexed to the counter affidavit as annexure capital B, the learned government advocate submits that against the question put to the applicant as to whether he had passed HS or class 12 in science stream with physics, chemistry and mathematics, the petitioner gave the answer within inverted comma, yes, close inverted comma. Full stop. The learned counsel therefore submits that the petitioner has clearly made wrong entries in the application form, which perhaps led to his consideration which perhaps led to the authorities allowing him to sit for the written examination and in the interview. Full stop. The learned government advocate submits that as per the advertisement, it is clear that in order to be considered for the post of APRO and fire and emergency services, amongst others, one has to be in the art stream, science stream, which the petitioner does not have. To stop, he therefore submits that the writ petition has no merit and the same should be dismissed. Stop. Upon hearing the learned counsels for the rival parties and upon perusal of the materials available on report, this court finds force in the stand and submission made on behalf of the official respondents, which is to the effect that the petitioner has misrepresented that he belonged to the science stream in his online application. And secondly, even if he is to be considered against the other posts which can be manned by candidates from the art stream, the petitioner being an OBC category does not have the required marks does not have before that has not secured the required marks stop. In other words, the last OBC / MOBC candidate selected appears to have scored 57.66 marks, whereas the petitioner is said to have scored only 50.26 marks. Stop. Next para. Under the circumstances and upon due consideration, I do not find merit in the writ petition. Accordingly, the same stands dismissed. No bust.
Highly observed.
Yes.
By the order dated 12/9/24, a direction was issued to them to produce the evaluation sheets of the written examination of the petitioner and respondent.
What is the challenge that you met here?
I have applied for the post of clerk in Assam Rifles. Even after qualifying all the tests, I have not been selected. Instead, private respondent has been selected who failed in the typing test. What they did is that they relaxed the norms of the typing test after the exam was conducted. So that is not permissible, Your Lordship. It is a settled law that rules of the game cannot be changed after the games has been played. This has been done in this case, instant case.
And on the other hand, you have qualified.
Yes, Your Lord.
The post you applied for is clerk.
Clerk.
Yes, Ms. Gayan.
Not qualified and he is not come under the merit list, madam. Kindly come to page number 62 of my affidavit in opposition, madam. Page number 62, serial number 157, madam.
Just a minute, huh? Will pagination is slightly difficult to be 62, you say. It's a chart.
Yes, madam, sorry.
Affidavit filed by respondent numbers 1, 2, and 3.
Yes. Internal page 67.
Page 62.
62, serial number 157, my lord. In the middle part, my lord. A small, my lord.
157.
Yes, my lord. Kindly see, that is in middle part, my lord.
There is no 157.
61, 62, my lord.
You said 157.
Yeah, 157, my lord. Have you seen, my lord, 157?
No, there is no 157.
May I go to my lord?
Just give it to her. It's very minute.
Yes, my lord.
One 157 seems to be missing. It starts from 200 something. Beginning was less than 100. In between some pages,
Original one, that I'm giving that one. Original record, my lord.
you have a copy?
Yes.
No, have you served copy to the other side?
Yes.
Is there, but-
Your copy is okay.
Yes.
But something is,
Something's wrong here. But there must be a second copy also.
the second copy.
Where's the second copy?
And I have that original, this one also. Huh? Okay.
Turning page 138. 138. Here, look, I say, 61 to cancel again. Serial number?
Serial number 157, madam.
Oh, same mistake here.
I'm giving the original of my this one.
Second copy, second file also has the same mistake.
Sorry, madam,
There's
there
the
is
page
one.
also missing.
One page is missing.
157, you see.
Madam, I'm giving the original record, madam.
Yes, what do you want to show me? One
Madam, here, the private respondent, my lord,
respondent number?
respondent number. Private respondent number.
How many private respondent?
Only one, my lord.
How many posts is there?
Only one.
Only one.
Only one post.
For Uttarakhand.
Uttarakhand. Okay.
My lord, in private respondent, my lord got
Private respondent number?
7, my lord.
7.
Private respondent got mark, my lord, 67 marks in the written examination.
67. Petitioner got
And petitioner got, my lord, 55, my lord.
55.
And accordingly, he comes under the low in merit, my lord, petitioner.
Hmm. What is the cutoff mark?
Cutoff mark is 35, my lord.
35.
Yes.
So he has got more than the cutoff marks.
More than balance, but the highest mark, the private respondent got the highest mark, my lord, 67, my lord.
So how is the selection done?
Selection done, but according
On the
to-
basis of
On the basis of, my lord?
those who score highest.
Yes,
No,
my lord.
no. There are 4 tests. And every test you have to pass, then only you will be selected in merit list. You will come in merit list. That is the scheme. So Your Honor, may kindly turn to page 16 of the
So according to you, the typing test was there.
typing test was there.
He failed in the typing test,
Yes.
whereas you passed.
I have passed.
Although you scored lesser maybe, but you passed in the typing test.
Yes.
He failed in typing test.
Yes.
So
And
if he
what-
fails in the typing test,
Then how can he be,
he cannot be selected.
cannot be selected?
And he has been selected because they have relaxed the
They
typing,
have relaxed after the examination.
typing speed.
Typing speed, my lord, that is. taken
Typing
to
speed was
decision-
relaxed.
Yes, my
Yes.
lord.
See, let us go to the advertisement. Where's the terms and conditions or the criteria? Let us see that.
Your
Have
Honor,
you annexed it? Have you annexed in the writ petition?
Yes,
The
page number 16.
employment notice 60,
Page number 16, 16. advertisement.
16.
Oh, it begins with 12.
Annexure 1.
Yes, Your Honor.
Okay, now where is the thing post? And so.
Question, start from page 18, my lord. For Uttarakhand, my lord, that is page 18, serial number 35.
No, the scheme of the examination,
The scheme of examination is page 16, Your Honor.
16.
Page 16,
Yes,
point number 19, Your Honor.
19.
The candidates who qualify in all respects, that is physical standard test, physical efficiency test, written examination, trade test, and medical examination test will be placed in merit list depending upon the trade and category wise vacancies allocated to states UTs. Instruction to join the training center for enrollment will be issued on the basis of merit list. Please note that merely qualifying in all tests does not confirm that candidate will be appointed. So basically, PST, written examination, trade test, and medical examination.
Hmm.
A candidate has to qualify in all these.
So where does the typing test come into?
Norms for typing test.
Typing test is included in what? Skill test?
Yes, trade test. Typing test is skill test. And its norm is at page number 26.
Before that, where is the post of clerk?
Page number 18, Your Honor. Uttarakhand.
Huh? 18.
Page number 18, serial number 35, Uttarakhand.
No, this is the post for clerk.
Clerk.
There's one post. You belong to the general category?
Yes,
There is only one post.
yes, Your Honor.
So, as per the serial number 19, merit list and call for training. It says candidates who qualify in all respects, physical, PST, PET, written examination, trade test, and medical examination test will be placed in merit list depending upon the trade category wise. Now, you say that the rules have been changed.
They
What
themselves
was
have
the rule before it changed? It was changed. What was the rule?
35 words per minute
Where is that?
at page number 25, 26, sorry.
Skill test,
Yes,
35 words per minute. Okay, this is the one.
clerk, number 1,
Hmm.
page number 26.
How much did you score? I mean, how much is the typing? How many words can you type?
The test was only to type 35 words per minute.
Hmm.
So I qualified in that.
How is that? Where is that? Where is your qualification?
So they themselves stated, they produced their report on last occasion on 12/9. And they said that I qualified. Only 13 candidates were able to type 35 words per minute.
Now, on what basis did you file this writ petition?
I filed the writ petition because I filed an RTI.
Hmm.
I asked for my dossier.
Hmm.
They did not provide. They said they are exempted. Later, I filed the even in I filed the written read petition. They did not say in their reply that they have relaxed the norms.
No, no. What is the ground for filing this writ petition? Without relying upon the counter affidavit or the records. Keep that for a side. On what basis did you develop your case?
Because Your Honor, if your lordship may kindly peruse.
You were aware about your typing result?
Yes,
Where is the statement? You passed, he failed.
para 8 of my writ petition.
Okay, I'll come back in 5 minutes. Take a break.
We have an unusual prayer mail regarding item number 38. It has been mentioned in as the matter has become infractious. In that matter, we are private respondent. The matter is relates to a transfer order, vice versa transfer order. So there is an stay order. May I pray for that stay order may be vacated, and so far it relates to the private.
This is not the time for mentioning. I'm sorry.
We are not aware at that time, so I could not mention.
Item 30, 1-3,
38, madam.
38.
Yes, well.
This is disposed of as infractuous.
Yes, well, stay order may be vacated, and so far it relates to the private respondent is concerned. Impugn order may be operative. That's impugn order challenge under the writ petition may be operative. In so far it relates to the private respondent. That is our.
If it's infractuous, it's infractuous. How can we make such kind of observation?
Yes. It is vice versa order. So far it relates
No,
to
no, no.
petition, it was become infractious.
If it's infractuous, it's infractuous. Only one line we can add. If interim order is there, it will be vacated.
Yes.
That much only.
Lordship.
Not beyond that.
Lordship.
What kind of prayer are you making? No,
Vice
no, no.
versa, my lord.
No, we'll not clarify anything of that sort. And probably I've signed this order also. See, if it's infractuous, it's infractuous. How many types of infractuous can there be? Infractuous means there's nothing left in the writ petition.
Yes.
It's closed. That's all. As if no writ petition was filed. Isn't it?
Well.
So they'll take care of it.
Obliged.
Yes. All right. You were showing me
Para 8 of the writ petition now.
para 8.
May I read, Your Honor?
From where did you get this information?
That information because I was present at the examination hall. And from reliable sources, I came to know that I have passed. And thereafter, I have also applied for the RTI. I have filed an RTI.
No, no. See, you have passed. Where have you said that?
Surprisingly, the petitioner name was not there in the said list even after performing well and qualifying in the skill test.
What list? Which list?
Skill test, Your Honor. Typing test.
List. You're saying list. Petitioner's name was not there in the said list. What is that list?
Merit list.
Where is the merit list? Maybe next
Yes, Your Honor.
page.
Page 53.
53. Provisional selected list.
Yes, sir.
Correct.
Yes. Sir.
Where is the name of the respondent number 7? Is it available here?
Yes,
Anywhere?
sir.
Where? What is
It's
his
at
name?
Page 57.
What is his name?
Narendra Singh. page 57, serial number 207.
This is respondent number 7.
Yes, Your Honor.
What does it show? Just the serial number, ID number, name, father's name. No other details are there, isn't it?
No. They just said they passed. They are
This is
selected.
a provisional select list.
Yes, sir.
After this, why is it provisional?
At
Any
the
other
time-
test?
No,
Any other test remaining?
no,
Then why is it provisional?
provisional because they have to go training and all. Only then it will be finalized
Okay, training is also required.
after the selection.
This is after the medical. Medical
Yes.
is done.
Yes,
So after training is completed, then will be the final list.
yes.
Or what? Okay. So your statement here says that list of provisional select list,
Finally.
petitioner name was not there. He was not able to type 35 words in English in a minute. This is on what base? On what basis here?
So I was present in the examination center.
And what is the reply in the counter affidavit?
They have stated that he has cleared all the examination.
Acha. Then?
No, and I filed an RTI. I sought for the skill test. They said we are exempted.
Okay.
Then they, in the counter affidavit, they said baseless allegation, our writ petition is based on baseless allegation. The respondent has cleared all the examination. Later, when they were directed to produce the record, they produced the record and now they are saying that we have relaxed the norms of the typing test.
In the affidavit or where?
After producing the record. In the affidavit, they had not stated. They had stated that they have cleared. The
So that-
private respondent is a meritorious. He secured highest mark in written examination and he cleared the skill test.
That is an oral submission.
Huh?
It is only an oral submission that they have relaxed the.
On 12/9, they produced the record, Your Honor.
Okay.
On the basis of record, Your Honor has passed the order. Your Honor may kindly check the 12/9/24.
No, the fact that they claim that the rules have been relaxed, the typing test has been relaxed. That is their submission only.
Yes.
It is not in the pleadings.
No.
How much have you relaxed? From 35 words per minute to how many words?
20, madam.
20. Why?
Because madam, kindly come to para number 21 of my affidavit in opposition, madam.
No, why have you relaxed?
Because madam, only 13.
What is the
candidates-
job required to be done? The name of the post is what? Clerk.
Yes, madam.
If you relax the typing test from 35 to 20, what
Yes,
kind
yes,
of
yes.
clerk are you expecting to employ?
Madam, kindly say this decision has been taken by the authority, madam. So in the region also, madam. Field test, madam. $412 candidates, my lord. All over the India will call for the skill test, which only 399 and 137 candidate passed and that test. 267 failed, my lord.
We are concerned with Uttarakhand, isn't it?
Yes, madam.
It's not available here, Uttarakhand.
Yes, madam. They are-
Where?
That is my lord, regarding the decision of skill test, my lord. That has been taken by the authority. my lord.
Okay, this is the decision taken by the authority, but it has also given specific names here.
Not given the specific name, my lord, but total number of candidates appeared before the passed in the skill test is only 137, my lord. Out of 399, my lord.
No, see, name of candidates are here.
Name of candidate, my lord,
Where is the name of the respondent number 7?
next in my affidavit.
No, in the record.
Skill test record is. That is in page number 56 of my affidavit in opposition. Skill test report, my lord.
See, this is the reason given, but you have not shown me the name of the respondent number 7.
My lord, kindly see page number 56, my lord.
56.
Yes, ma'am, of my affidavit in opposition, ma'am.
Yes, 56.
56, 57, serial number 351, Sanjay Singh Gangolia. This is the petitioner.
Hmm.
Then 348, private respondent number 7. That is the result of skill test, my lord.
This is after relaxation.
The relaxation, my lord.
When was it relaxed?
That was relaxed on 19 to 25 January 2017. ma'am.
When?
January 2017.
January
Sorry, June
2017.
2017, ma'am.
From where you're seeing that?
Madam, that is in the list of the state test, madam. Date of my lord decision, my lord.
Where?
Decision, my lord.
There is no date in this, what you have shown me. Where is the date?
There is an office note, my lord. And my lord, merit list is prepared on the basis of my lord OM, my lord. Kindly see page number 17.
Yes, Ms. Gayan,
Merit
you were
list is prepared on the basis of OMT, mal. That is an office note, mal.
Hmm?
Last part, mal.
Last part means?
There is an handwriting, mal, not handwritten office note is there, mal.
What does it say? The handwritten?
There are 249 candidates, mal, total.
Hmm. What are you saying, Ms. Gayan? I'm not being able to follow.
An office note of regarding that decision taken by the authority for decreasing the total number of ward, mal. Office note is there, mal. From 35 to 50, 20, mal. Regarding, mal, merit
That
list.
decreasing of the words per minute is not available in this page which you have shown me. Either in the typed portion or in the handwritten portion.
Type portion is there, madam, but date is not there, I think, madam. In last page, madam.
In this page, what is there?
Next page, madam. Type.
Huh?
Next page is next page.
Next page.
Yes.
Pregnancy test.
No, wait, above the pregnancy test, there is a type. Above the pregnancy test, madam.
Final merit list of 229 selected candidates is placed opposite.
And that is there, madam.
What is there? I don't know what you're saying.
Here it, madam.
Read.
Trade test typing test for the post of Howler clerk was conducted on 19 June 2017 to 22 June 2017 at the DFU ARTC and C Center. The majority of candidates could not achieve the prescribed standard of typing test, hence keeping in mind the maximum subscription of the available vaccine clerk trade, the competent authority decided to dispense the typing test criteria to 20 WPM from required 35 WPM, madam. That decision has been taken, my lord.
So when was that decision taken? Date?
Madam, I'm giving the date also, madam. That is in flag B.
What is the date of the decision?
I'm giving one. Yes, madam. Yes, this is right. Case 19 and 21.
I just want the date,
Yes,
not
that
the
is
page
there,
number.
madam. Yes, that is there.
Give me the date. Don't give me page.
Yes, I'm giving.
Give it to her.
Give it. 22 June 2017, my lord.
22,
June 2017.
2017. $35 words has been relaxed to
20.
for whom?
For my lord, relaxation for conduct of trade test for.
For which categories of persons?
That is, my lord, for the
Test was conducted where?
test was conducted on
Where?
Deepu.
In
Deepu.
Deepu.
Yes, my lord.
For all the
Yes, my lord, for all this, for all the candidates, my lord.
for all the candidates in
Yes,
Deepu.
my lord.
Relaxation was done in respect of everyone.
Yes, my lord, for all the candidates, my relaxation was done. For that, under the advertisement who come under the advisor, for all the candidate relaxation has been done, my lord. And
And-
my lord, regarding the merit list, my lord, I want to show one OM, my lord, and list.
No, we'll come to the merit list later on. Just a minute. What is the date of the advertisement?
Decision has been taken on 14/7. Decision was taken 22 June 2017, my lord. Hmm? 5-0.
See, there are candidates from, the number of posts is given to state-wise.
Yes, my lord, state-wise.
State-wise.
Yes, my lord.
So relaxation was done in respect of everyone.
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 Does it indicate there?
Yes, my lord.
Let us see. 22/6/2017, you said.
Yes, my lord.
The council. So this relaxation is not in respect of a particular individual. When the typing test was conducted, everyone who had not been able to get that 35 words per minute. So they said, let us relax.
But can they do this?
So what is wrong in that?
It is a settled law. Once the process has started, one cannot relax the eligibility criteria, recruitment process. Then what about my legitimate expectation? I have a legitimate expectation to be appointed. They are saying I am low in merit.
And you are low in merit.
How? I qualified all the criteria. I passed in all the.
No, it's not about qualifying. Comparatively, your marks are lower.
No, only the pass mark
That
is 35
I
marks.
think that is not in dispute, I think.
35 marks.
There's
was
no
the-
dispute
that
that
there is no
this
dispute.
is the cutoff marks. You have got more than the cutoff marks.
Yes.
But probably the respondent number 7 has got much more.
On written, only on written examination, he got 67,
No,
I got
correct.
55.
Correct. See,
But on the contrary, I typed 35 words.
Hmm.
He was not able to type 35 words. In fact, they have to relax, and God knows if he was able to type 20 words or not.
My lord.
And can this be done, Your Lordship? This is a question. Can the, because what can be relaxed has been stated in the advertisement.
like what?
Age,
And
age, height relaxation can be done. And age.
see, supposing it was a case of relaxation in respect of a particular individual. Okay, we relax for him.
But
Then perhaps there would
But
create,
your lordship, this.
but if it is a case wherein, you see, when all the participants were there, same rules were applied. Authority at their own wisdom says that, see, since we are having difficulty in people not qualifying 35, we go
They
down
did
to
not inform us.
20.
They did not inform us.
Hmm.
I appeared on 21st.
Hmm.
They took decision on 22nd.
Hmm.
That is why I filed.
Yes, my lord, after that.
After seeing, after seeing the typing only, then they said that we'll have to take this call.
They had the inform. I have prepared for this examination. I have undergone training to type 35 words per minute. That is why I could not concentrate and study for written examination. That is why I scored 55. But I knew I had to pass in all examination.
Okay, just show me what is that?
My
which is shown
lord,
here?
Assam Rajya Technical and Recruitment Rally for the year 2017 of fill up 614 vacancies in 35 trade comments with effect from 20 March 2002 onward. The details vacancy advertised for the recruitment is placed opposite. Board proceeding, my lord. Compare the final result of the above rally comprising of merit list of 417 candidates who have qualified in all mandatory tests in the place opposite. Trade test, my lord. That is regarding for all the candidate list, my lord. Candidate that has been done, my lord. Not only for the particularly for the petitioner, my lord. And I have also my lord.
So on the basis of 20 words per minute, how many people have you selected?
Total, my lord, select list of selected candidate, my lord, this one.
That is in particularly regarding to the post of clerk, isn't it?
Yes, ma'am.
So clerk post appears to be a variation from 1 to 4. There's one state which has 4 posts. Hmm?
The total selected candidate list of the selected candidate is, my lord. 188, my lord.
188.
Yes, my lord.
In the post of clerk.
Yes, ma'am. Or all over India, ma'am.
And the criteria was 20 words.
Yes, my lord. Criteria 20 words. On the basis of that decision, my lord.
Is it shown there in your records that
Yes, ma'am. This is the.
decided to relax to 20 words per minute for all the candidates?
Yes, my lord. So, my lord, in that my
See, if that is the case, in the first place, why didn't you make that response in your counter affidavit?
please see my lord page.
In your
21.
counter affidavit, you should have mentioned.
Yes, my lord. Kindly see page number 8, paragraph 21, my lord.
Page number 8.
Paragraph 21 of my affidavit in opposition.
Hmm. Yes. What does it say? Does it speak about relaxation?
Yes, my lord. According to the skill test for the categories of the personal assistant and clerk.
No, from where you're reading, tell me first.
My lord, paragraph 21, my lord.
It starts at that the amendments made in
Yes,
paragraph
yes,
number.
yes.
You are
It
reading
is
from
only
which line?
submitted
Hmm?
From the beginning, I am reading, my lord.
Read.
That the amendment made in paragraph 6 and 7 of the petitioners.
No, amendments is not in 6 and 7. Amendments in paragraph 8.
The page number, paragraph 21, my lord.
Paragraph 21 is not relevant. That's what I meant.
My lord.
See, the amendment made by the petitioner is at paragraph 8. Respondent number 7, name was included in the said list. Even though he was not able to type 35 words in English in a minute, against this specific amendment in paragraph 8, what is your reply?
Paragraph number.
It is not in paragraph 21. It is in paragraph 23. Come to paragraph 23.
Yes, my lord, paragraph
Hmm.
23.
Show me
It
where in
is-
paragraph 23 have you said that we have relaxed?
This and respondent authority published a list of selected candidates in which the petitioner could not be accommodated below being the low in merit. Petitioner stated that scored less mark than 55 against the cutoff mark 67 scored by the respondent. Mayor Peluso's merit list will clearly bring out that the petitioner was low in merit and could not be appointed. Merely qualifying in the typing test will not, however, make the petition eligible for selection as there is no discrepancy in selection process which base all appointment purely on merit. As regard the contention of the selection of Narendra Singh, it is submitted that he has cleared the mandatory test, including the medical examination, and scored the highest mark in 67. That is 67 in the written test. The top of the merit in the category of the clerk against the vacancy of the Uttarakhand. Only one vacancy was allotted to the state of Uttarakhand. Therefore, the petitioner could not be offered the appointment. The merit list, result sheet of the skill test, and the result sheet of the medical examination has already been annexed. Result sheet of the PSTN in respect of petitioner and respondent annexed here. My lord, kindly come to the merit list, my lord.
No. We'll come to the merit list, no doubt. But tell me where in paragraph 23, which is in response to the statements made in paragraph 8 and 9, have you stated that since persons could not qualify 35, we decided to relax on 20. And this concise decision was taken by the competent authority. That is not revealed by you. Only when the records were called, you had shown us that. So you withheld this information from the court. That is why we always insist on pleadings. They will say something and the other side will have to counter that.
But
Either
in,
deny or admit it.
but in paragraph
But you are just avoiding it. You are avoiding it. You're not saying anything. You're saying that it's very high on merit.
but in paragraph
Now, supposing you are appearing in matriculation, you scored very high marks. Your subjects are arts, science, commercial geography, mathematics, whatever. You scored distinction marks in all the subjects, but you failed in mathematics. Minimum pass mark is 30 marks. You got only 20 marks. Can you be selected?
but in my paragraph
So the
20
same logic applies here because the condition here in the notice is that only those persons who qualify in all the subjects, in all the fields will be placed in the merit list. And you come up with a provisional merit list wherein the name of the petitioner is not there. And private respondent number 7's name is there. Although according to the petitioner, he is not qualified in the typing test.
in paragraph 21 of my affidavit in evidence, I have stated, my lord, according to the skill test category of the personnel and clerk were conducted at depot, altogether 412 candidate personnel, assistants, and clerk from all over the India were called for the skill test, out of which only 399 reported and 137 candidates passed the test. 267 failed and 13 remained absent, my lord. That's why decision was taken, my lord.
So what will happen to those who pass then? They have failed. Those who pass, they have gone. They have lost their chance. Why? Because they passed, but they had scored less in merit in the written test.
That provision is also in that advertisement, my lord. Kindly
Where?
see,
Where?
my lord, kindly see. I've stated in, and he did not deny in their
The advertisement.
In my lord, no, kindly see, my lord, paragraph 8, page 21, page 8 of my affidavit in opposition.
Yes, I'm in that page only. Which one?
8, no, paragraph, page 8, the relevant portion in page number 9, my lord. May I read my from the first line?
In this regard, the attention of the honorable will drawn toward the policy laid down by para number 2, subparagraph 12 and 15 to 16 of MHA so and so dated 25th June 2000 and as regard to preparation of the merit list. Merit list in each category, namely general, OBC, SC, ST, and ex-serviceman is to be drawn separately in respect of each state and duties on the basis of the aggregate marks obtained by the candidate in the written test. My lord, that OM is in page number 16 of my
No,
affidavit.
please continue to read. The point of consideration
The
has.
point of consideration is that the candidate for being selected and has to pass the qualified in all mandatory tests and come in the merit based on the marks scored in the written test. Further, there is no such state quota as alleged by the petitioner in the skill test. Skill test is carried out purely on the individual basis and the candidate has to qualify in the same before being medically examined. It is worth mention here that the defined stage of recruitment process were executed by the defined board of officers and according to the laid down procedure, and each state of the recruitment is supported by the documentary proof signed by the board of the officer, whereas the petitioner has leveled mere allegation without any proof, my lord. Then kindly come to that MH, my lord, OM.
So what is the proof? See, your statements here clearly shows that all the tests are mandatory.
Yes.
So when the typing test is mandatory, if a person does not qualify, and if the person qualifies, you put him out, and those who are not qualified, you put him in because you have relaxed it.
He is no, he is in the after my lord qualifying those who get the more than 20 marks in that ward, my lord, 20, then all are come in the selected list, my
Very
lord.
good. They'll come only, but question is whether you can do that or not.
My lord, as per OM,
Whether you can raise, you can decrease the standard of typing test.
that decision has been taken for all the candidates, not the particularly, my lord, for them.
That's what I only said. I only said that it's taken for everyone. But
For
even then, even if it's taken for everyone, then what about those person who is qualified? Although may have got lesser in the merit, but qualified the typing test.
Yes, my lord.
Are they not prejudiced?
No, my lord, they are not prejudiced because, my lord, if they got the lesser mark or the more mark in the typing test, my lord, all are come in the merit list, my selected list, my lord. And after the selection, my lord, they prepared the merit list on the basis of OM, my lord.
On the best of?
OM, my lord. That is in page number 16 of my affidavit in opposition, my lord.
16.
Yes, my lord.
Let us see your OM.
Everybody will get chance, my lord, after that, my lord. Then, my lord, they prepare the selection candidate of selected candidate that is in OM dated, my lord. Kindly see page number 16 OM.
16 is not OM.
16 is that relevant portion is in page number
Then you show me tell me the
24,
page number.
24, my lord.
Then why you take me to 16?
16 is the first page of that OM, my lord. 24, my lord.
But 16 is not OM.
16 is forwarding, my lord.
Is this an OM, page
No,
16?
my lord. Page 16 is forwarding, my lord.
Then?
Page 24, my lord. Page 24, 13, Roman 13, my lord.
Yes.
Merit list in each category, namely general, SC, ST, OBC, and ex-servicemen will be drawn separately in respect of each state or union territory on the basis of aggregate marks obtained in the written test, my lord.
Subject to you qualify the typing test, isn't it? Otherwise, why do you put typing test? Don't put typing test at all then. If you want to go straight by the merit. If you come back to page 16 of the writ petition, page 16, the advertisement, paragraph 19, merit list and call for training.
Merit list and call for training.
Read, please read.
The candidate who qualify in all respect, that is physical test, physical efficiency, written examination, trade test skill, and medical examination. Yes, my trade
Will be placed in the merit list.
yes, my lord.
So
Depending upon
if one does not qualify the typing test, he cannot be in the merit list. Now, they have been put in the merit list. Why? Because you have scaled down the score. I mean, scale down the qualifying words from 35 words per minute to 20 words per minute. And if it's a clerical job, see, a clerical job, of course, nowadays people use computer, but even if computer is used, you still type, isn't it? So you're in fact, you are compromising the quality of work. A person who can type 35 words per minute
My lord,
is shown the door, whereas person who can type only 20 words per minute, come, you take the appointment.
no, my lord.
That is what has happened.
But no one will prejudice, my lord, because everybody will get some, everybody is getting chance, my lord, those who type more than 20, my lord. No one will prejudice, my lord, for the decision of that decision for taken by the authority, my
That
lord.
is where I think you're wrong in that. You said no one will be prejudiced. Everyone is in the merit list. Now that
And-
everyone in the merit list has made the chance of the petitioner nil because he has got less in the written test.
Yes, my lord.
Now, if it was compulsory or if it was not compulsory, then one has to sit for the typing test. Forget about how many words you can type, but you have to sit. Then it's okay. But you lay down the criteria saying that 35 words per minute. Then one fine day you find out that most of the people cannot type 35 words. They said, now we come down. So what will happen to those who have typed 35 words per minute? Their chance goes.
No, my lord, they will come under the merit list, my lord, because there is a certain criteria in the merit list. How can the merit list will prepare, my lord? That is as per the OM, my lord. That criteria is also there in as I have mentioned in my affidavit in opposition, my lord. OM, my lord.
What does the OM say about the typing test? Anything in the OM?
Recruitment procedure.
Hmm?
From page 20, recruitment procedure, madam. Method of selection. Physical standard, physical efficiency, mechanical, written test.
There's nothing written about typing test.
Yes, ma'am.
Hmm? Then why do you put that typing test in the advertisement then? Don't call for typing test if your OM does not provide. Relaxation is basically on what? Height, chest, and all that.
Yes, Your Honor.
You had said something about age also. Age is not there. It's basically height and chest. This OM is meant for which category of posts? Constable in Central Police Force. What about clerk? They also considered as constables. Ms. Gayan?
Yes, madam. Respect for appointment as a constable in the central recruitment constable is an important process.
Constable cannot be come as clerk.
Which is the guide?
I have to confirm that, my lord, whether
You confirm it.
I have to confirm this one, my lord.
But then why did you put this in extra then, if it's not applicable?
I think this is applicable, my lord. But I have to confirm whether it is applicable. That's why I put this an exam, my lord. But I have to take instruction on that, my lord. They must have something on that, my lord.
Okay,
That is
let her get some clarification.
Already been 7 years. From 18, this is of 2018 case. It's been 7 years.
No, it's okay. So you wait for another few days. Let it be clarified properly.
Because otherwise, it is a settle that once an examination process has started, it cannot be relaxed. The terms and conditions of the advertisement. And if they want to relax, they can do in the advertisement itself.
Please write down. It is the case of the petitioner that he applied for the post of clerk for the state of Uttarakhand. No, he applied for the post of clerk in the Assam Rifles. Against the one post reserved for the state of Uttarakhand. Stop. Although he passed in the written examination as well as in the typing test, his name was not included in the provisional select list. Whereas, the respondent number 7 who failed to type 35 words per minute as was required, was placed in the said merit list. Stop. The respondents have filed a counter affidavit wherein they have annexed the scheme for recruitment of constable in the Central Paramilitary Forces. As an extra R1. Stop. A perusal of the same does not indicate anywhere that typing test is required. And moreover, the scheme of the recruitment is meant for constables, whereas the present case is in respect of clerks. So, Ms. A. Gayan, learned CGC shall therefore obtain appropriate instructions as to which guidelines is relevant for recruitment of clerks in the Central Paramilitary Forces, more particularly the Assam Rifles. When? Ms. Gayan?
Immediately after vacation or before, my lord?
That long? Is it not possible this week? Any day this week?
This week, my lord, then my lord,
Friday?
then this Friday, my lord.
This Friday?
No, then Tuesday, Wednesday, my lord, 9th.
Why?
My lord, this Friday.
You just get all of that guidelines, whichever guidelines it is. Board wants to see whether that typing is required or not.
Yes, my lord, this Friday, my lord.
Friday?
I'm
List,
planning.
you try.
Bring-
You try. List the matter again on Friday.
Much of it.
Oh, there is a
We were directed to call for a record. The records have not yet been received. Otherwise, the matter relates to disciplinary proceeding. May I pray that the matter will be fixed for hearing on some date after Vimu vacation. By the time I'll get the records. So record. Because the main issue under the contention is basically the cross-examination, whether the delinquent officer, the petitioner, was allowed to cross-examine the witness or not.
Some the other
He has
issues also
stated-
dear, my lord,
He
not
has
only
stated
the
basically that
cross-examination
cross-examination
part,
was
my
not done. We are stating in an affidavit that cross-examination was done. So that is where records are necessary.
only that question record is will required, my lord.
From where the records is supposed to come?
Here only, Home and Political Department. So
Home and Political Department.
because
Okay.
the Assam Police Headquarters written on 13th of February.
It's okay. It's okay.
to,
So how much
call
time do you
for-
require?
After the Vimu vacation, Your Lordship,
Let
after-
it be, let it be on the month of May, my lord. On
May.
Any hearing date, Your Lordship.
any hearing day on 13th of May, my lord.
Penalty is increment, one increment, stoppage
Only
with
stoppage of
with
one-
cumulative
one
effect.
cumulative For one.
You suggest a date?
My lord.
First week? When do you want it?
13th of May, Your Lordship.
13th of May or 15th of May,
15th of May.
15th of May also. do, my lord.
15th of
All
May
right.
will do.
15th of
As
May.
agreed to by the parties, list the matter on 15th of May for hearing. For admission hearing,
Admission hearing, my lord.
the learned government advocate shall produce the departmental records on that day.
My lord, so several times the court has directed to produce the records. But here Dispur is the location, my lord.
Yes, they'll produce this time. Mr. Bora will
It is
definitely
matter, my lord.
do. Yes.
I'll get it. Your Lordship.
This matter become infractious. It become infractious.
Infractions.
But what kind of prayer you making? You want officiating
Promotion.
promotion, not regular promotion. You want officiating promotion. Come, what is your good name?
You doctor.
Mr. U. Datta, learned counsel for the petitioner submits that the writ petition has become infructuous. Mr.
N. Upadhyay,
N. Upadhyay, learned
Standing Council Irrigation.
Standing Council Irrigation Department agrees with the said submission. In view of above, the writ petition starts disposed of as infructuous. Yes.
All right.
May I please?
Yes.
Private respondent has already appeared, but they have yet to file their affidavit.
None of the respondents have filed counter, isn't it?
Lordship?
None of the respondents have filed counter. Even the
Government-
official respondents also have not filed.
Yes.
Private respondent is already presented.
Yes, appeared.
Yes.
I am for item, respondent number, private respondent 9 and 10, madam. They
Yes.
are already retired. One is retired, another is retired in the next month.
When?
On May 2025.
You tell me the exact date, we'll record it. Respondent number?
Respondent number. Oh, sorry. I'm opening this. Respondent number 9, my love, already retired on 31st of January 2023.
Let's see. Then?
And respondent number 10 will retired on 31/5/2025.
30?
31/5/2025. Respondent 10.
Or 31/5,
My love,
2025,
25. Respondent 10.
in the month of May.
May.
Hmm.
Right, respondent 9 will retired on 31st of January 2023.
So 9 and 10 are the private respondents.
Yes, Lord.
The rest are official respondents.
Yes.
So relief claimed is the appointment to the post of junior assistant, correct?
Yes, Lord.
In lieu of the private respondents.
Yes.
So cause of action still survives in respect of respondent number 10. We're in April, next month.
Madam.
Are you going to file any affidavit?
They are not contacting me, madam. I am unable to.
And okay, who's for the official respondents? PHE. PHE. You are there? Mr. KP Pathak was there, I think. R.R. Gogol, sir. None of them are here today. All right, pass over for the timing. What is your good name?
B Islam, madam.
B Islam.
For private respondent 9 and 10. Develop.
This case, your lordship, dispute relates to pensionary benefits payable to the legal heirs of the deceased, your lordship, employee. And I, your lordship, I'm representing the first wife and his and her, your lordship, sons and daughters, your lordship, 3 of them. And my learned friend, your lordship, he is representing second wife and his 2 sons, your lordship, three.
1 son, 2 daughters.
Now, your lordship, ultimately, your lordship, so far as they accept the second wife, your lordship, all others are, your lordship, entitled to get the benefits of your lordship, retirement benefits. In that terms, if your lordship directs the authorities, your lordship.
You're for the first wife.
I am first wife and 2, your lordship, of his, your lordship.
They are the petitioners here.
They are petitioners. here.
All of them.
All of them.
First wife and 2 children.
2 children.
They are still minor.
No, your lordship.
Then
Not family pension, your lordship. Family pension is not there, pension is not there, your lordship.
there is only one petitioner,
No, your lordship.
Alpana Lekharu.
She's the petitioner, your lordship.
Yes.
But
so-
your lordship raised her children, your lordship. They
No,
are not
rest
there.
means there's only one petitioner.
One petitioner.
Where are the other
Lordship.
petitioners?
Now, family pension is not there, your lordship. Pension itself is not there in the housing pay, house paid, your lordship.
So
Housing
what,
board, your lordship.
so what is the,
Rest, your lordship, entitlements and leave encashment, your lordship, gratuity. CPF, your lordship.
how do we decide that? There must be some nomination also.
Yes, my lord. Nomination, yes, my lord, but the law is, my lord, that it has to be 50-50%. The initial stage, my lord, I had submitted, my lord, that if the matter, if the amount is divided 50, I do not have any objection. My lord.
See, division is one thing, but what about the nomination then? Even if there's nomination, there has to be still have to be divided.
In fact, my lord,
So
I-
it will prevail over the nomination.
here, my lord, nomination was in my favor, my lord. Because the my lord, first wife was was a working lady, my lord. She was a government servant. If your lordship kindly comes to the affidavit at page 29. Affidavit files the respondent number 4.
Problem is with the pagination. Like I said this
Yes, yes.
morning also. Your 29 and my 29 is not telling.
That the running page system has your also created some problem.
The lordship will kindly take the affidavit of the respondent number 4. Affidavit in opposition of the respondent number 4. my lord.
Respondent number 4.
No, move to running page. I mean, it has to be running page itself, you know, page 29.
Annexure 4.
Annexure 4.
Okay.
This
Yes.
was the nomination in favor of the second wife. You know. Since the first wife was a working lady in the state government, you know, this was the nomination. And on the basis of which, my lord, the process was initiated. But the fact remains, my lord, there are two apex court judgments, my lord. In the case of Rameshwari Devi, we'll just place those.
Rameshwari Devi, your lordship, second wife is not entitled, that's what.
No,
But children of second marriage are
Yes.
entitled.
The law says that, my lord, the second wife is not entitled. But the children are legitimate and
Offspring,
the offsprings are there, they are eligible, otherwise entitled to the pension, pensionary benefits.
That's no dispute about that. Your
So that is why, my lord, since there is no pension in this, in the department, my lord, the housing board, so, my lord, the whatever pensionary benefits, the retirement benefits, they are entitled, my lord. Let it be divided into two parts. The first part, my lord, 50% will be borne by the.
You come up with an agreement then. On
Not
the,
two parts.
on the basis of that agreement, we'll decide.
Three from this side or upon.
Three will be, in that case, my lord, I will be benefited because we are 4. So we are 3, they will be. Even otherwise, my lord, I have 3 children, they have 2 children. So 3 versus 3. So it will be 50-50 otherwise. First wife and her 2
children.
2 children.
Second wife, 3 children.
3 children. So
Second wife not entitled, so 3 children will get.
So, my lord, 3 is to 3.
3 is to 3.
So if it
Okay,
is,
again, back to the question I've made is what about, was there any nomination made by the employee?
yes, well,
That your lordship can be clarified by the department, your lordship.
nomination, that is why I refer to page 29. And this is your lordship, page 30 is
No,
the.
can we say that in spite of the, what nomination is made, you still divide like that?
Yes, that can be done.
No, but
We
what
have
is,
no
where
issue
is,
with that.
where is the provision?
In fact, your lordship, therefore, your lordship, the departmental advocate was directed to your lordship file an affidavit showing your lordship the amount your lordship due against the deceased employee, your lordship.
It has not been filed?
Not yet, your lordship.
Who is the departmental advocate?
T. Gogoi, your lordship.
T.R. Gogoi. Assam State Housing Board. When he'll come? No, when can he come? When will he come? After 1 week.
Lordship, may I suggest something, you know? Lordship will finally dispose of the petition, you know. With the observation, you know, that the second wife, otherwise I will be benefited if because of the nomination. I do not have any objection if the amount is divided 50-50
between the
parties. That on that same basis, I will not be claiming. You know. That is my instructions. So Lordship may dispose of the whatever amount is due from the department, from the board, that will be divided if you, and the respondent number 4 does not have any objection to it. I openly submit before the honorable court.
You are the respondent number 4.
I am the respondent number 4. It's pending since 2020, 5 years.
Okay. This is item number 10. Heard Mr.
S. Bothakur, your lordship.
S. Bothakur, learned counsel, but your name is not there in the cost list.
I have filed, your lordship. Why subsequently I have
S.
entered it.
Bothakur, learned counsel for the petitioner, and Mr. R. Dey, learned counsel for respondent number 4.
On behalf of SK Mehdi.
Stop. Also heard Miss R. R. Saikia, learned counsel on appearing on behalf of Mr. S.K. Mehdi. What is he? S.K. Mehdi. S.K. Mehdi appearing for Accountant General Assam. And Miss N. Kalita, learned counsel appearing on behalf of Mr. T. R. Gogoi, Standing Counsel, Assam State Housing Board, representing respondent number 3. Stop. Having regard to the nature of the controversy and as agreed to by the learned counsels for the parties, the writ petition is taken up for disposal at this stage. Stop. Next para. It is the case of the petitioner that she is the first wife of late Lalit Chandra Lekharu, who was an employee of Assam State Housing Board, Guwahati Zonal Branch, who died of natural causes on 10/7/2019. Stop. After his death, the petitioner approached the board for pensionary benefits, but she was informed that since her late husband also had a second wife, both the wives would get the benefit by dividing the same into half. Stop. According to the petitioner, she got married with her late husband in 1983. According to his Hindu rites and rituals, and 2 children were born out of their wedlock. So, her late husband, without divorcing her, apparently married the respondent number 4, which came to our knowledge only after his death. Is that correct?
It was,
No,
in
no,
fact, sisters, they were sisters.
No, that is not correct. Lord.
Not correct.
Not correct.
She knew, your lordship.
Okay.
Yes.
Cancel
They were
that.
siblings.
The Allah said it's concealed. Apparently married the respondent number 4. Stop. That's all. Stop. That out of the marriage with respondent number 4, 3 children were born. To stop. Therefore, in view of late Lalit Chandra Lekharu, having married, having two wives, the respondent authorities have contemplated to divide the pensionary benefits amongst his legal heirs. Mr. Borthakur, learned counsel, submits that it is an established law that a second wife will not be entitled to the pensionary benefit of her late husband, but their children will be entitled to the same. Stop. At this stage, Mr. Arde, learned counsel for respondent number 4, submits that the respondent number 4 has no claim to the pensionary benefits for herself, but as her 3 children born out of our wedlock with the late employee being entitled to the pensionary benefit, the respondent number 4 will restrict her claim only to that extent. And the same is the instruction received by him from the respondent number 4. Mr. Borthakur, learned counsel for the petitioner, also agrees to the said submission. Next para. In view of above, and as agreed to by the parties, this writ petition is disposed of by directing the respondent authorities concerned to work out the pensionary benefits entitled to late Lalit Chandra Lekaru and divide the same equally to the petitioner and her 2 children on one hand, and the 3 children of the respondent number 4 on the other. Such an arrangement has been directed despite the nomination made in favor of the respondent number 4 by the late employee, since the respondent number 4 has agreed to such a settlement. Stop. The respondent authorities concerned shall work out the entitlement as expeditiously as possible and preferably within a period of
One week. No.
I don't think 1 week is
She was thinking of the adjournment.
may-
3 months. She said.
within a period of 3 months from the date of receipt of this certified copy of this order. And disburse the same to those entitled to, as stated herein above.
Obliged, my lord.
You write it's some Mr. D. Bora, learned government advocate, OPS for respondent number 1. The R.R. Gogoi.
Lordship. Lordship, here they are seeking promotion from the post of Khalasi, grade 4, your lordship. And it's a well settled law that this Khalasi posts are ex-cadre posts, not a feeder post, your lordship. Promotion. In fact, there are judgments which your lordship have been passed, your lordship. I have the copy of the judgment, your lord.
So what does it say?
At para 9, your lordship. The next page. As promotion to higher rank can be considered only from the feeder cadre, and since the writ petitioner are not encadred in the feeder cadre, the learned judge opined that they are entitled to claim promotion to the higher cadre. The learned judge found that the regulation of the incumbents in the temporarily created personal post was accepted without protest with the attendant terms and condition thereof. It was observed that the beneficiaries of the regulation order cannot turn around and assail the decision of the government, which wanted to confer limited benefits through the process of regularization. On plea of discrimination, those already encadred in the feeder cadre, the court held that the incumbents regularized against the posts created personally to them are on a different footing, as their posts being temporary nature and were not added to the cadre strength in the department. Thus, the plea of discrimination was negated. Those who were working in the post within the notified cadre of the department. On the basis of the reasoning, the prayer for promotion made by the ex-cadre incumbent holding the post on personal basis was found to be untenable, and according the case came to be dismissed under the common judgment 16/3/2015. So basically here the Khalasi is an ex-cadre post, your lordship. It doesn't come under
Now,
feeder post.
are we talking about Khalasi in this case?
Yes. The petitioners are working as Khalasi grade 4, your lordship.
So they want to be promoted to the
They want to get promoted
junior assistant.
to junior assistants. But since
The post they are holding is a personal post.
Personal post. As per this, their page 12, your lordship. The masteral worker hereby regularized as Khalasi with effect from so and so. So their appointment is the masteral worker in Khalasi, your lordship.
Lordship, in this regard, if he is submitting something, then Lordship, fix on Friday. I can clarify all this.
Friday.
I'll clarify. If possible. Otherwise, next.
We'll have it on Monday or on hearing date, perhaps Tuesday.
Tuesday.
Hmm. Parties are represented by the respective councils. Mr. B. Islam, learned counsel, appears for respondent number 9 and 10 and submits that respondent number 9 has retired on 31/1/2023, while the respondent number 10 will be retiring on 31/5/2025. He also submits that he needs some more time to obtain instructions from his client. Next, but at this stage, Mr. R.R. Gogoi, learned counsel, appearing for the
PHE department, lordship.
PHE.
PHE.
PHE department submits that the petitioner. How many petitioner? Two.
Two petitioner.
The petitioners are working as Khalasi, and it is a personal post. Since it is a personal post, they cannot claim further promotion to the post of junior assistant. Stop. In support of his submission, learned counsel has placed reliance upon the. When was this order passed?
This order, writ appeal number 124/2015, your lordship.
Order date of the
The
order.
date is not here, lordship.
Then from where you got this copy? Only case number is there, nothing. Hmm?
It's
Dilip Talukar versus State of Assam.
It's 2017 2 GLT.
Huh?
It's reported, your lordship, 2017 2
You
GLT.
tell me,
I'll get this.
has relied upon the case of
Dilip Talukdar,
Dilip Talukdar versus
the state of Assam,
State of Assam, reported in
2017 2 GLT.
2017 to GLT.
GLT 376.
Please repeat. 2000.
It is 2073 GLT. Can just take the soft copy ballot. I'll get it.
It's okay. You tell me the
2017 2
citation.
GLT 135.
Sorry.
2017 2 GLT 135.
135. You got it? Up to this submission, learned counsel for the petitioner seeks some time to take instructions. In view of above, list this matter again.
Tuesday?
On Tuesday.
Yes, sir.
Please give the date.
Obliged, lordship.
Highly obliged, sir.
May I please, your lordship.
Item 11. Yes.
Lordship, this is the issue involved in this writ petition relates to recovery of the excess payment. And secondly, the next increment, which was due on the first day of July, entitlement of the next increment as he has retired on June 30th. The fact of the case is that the petitioner hearing, he joined CRPF as a constable on 11/11/1980. Thereafter, he got one promotion, and subsequently there was no promotion. So in the year 2010, he is entitled for the third MSCP. That was granted. In between, he was given a penalty in the year 2010. That penalty for stoppage of one increment for 1 year. As a result, subsequently, by order dated 17/9/2019, issued by the respondent number 4, whereby the pay was refixed by the among third MSCP was granted with effect from 1/7/2012. And instead of initially it was sanctioned from 1/10/2010, that is at lordship that order of sanction of the MSCP, third MSCP, I have annexed. This is Annexure 3. The relevant portion of the order is at page 21. Fourth column.
Yes.
Fourth row, it is granted third MSCP with effect from 11/11/2010 in payment to 9,300, 34,000, such and such. His pay may be fixed. So he was given this an MSCP. And thereafter, by order dated, the impugned order is in the next page. It says that the third MSCP, it is in page 23, and except 4 is the impugned order.
Cancel due to.
Cancel
with-
due to withhold of
withholding of-
one increment
No.
without cumulative effect. I'm not on the cancellation, but recovery that was made subsequent thereto, because that cannot be, because Rafiq Mercy is very clear in this regard.
You are against recovery.
Yes, Lordship. That was recovered. The entire amount was deducted from my pensionary benefit. There was an internal communication that they have annexed with the affidavit in opposition, wherein they have stated that his recovery was made. The commandant was directed to make recovery. Accordingly, commandant has recovered the entire amount from me. So I am on that. That cannot be done because of the settled legal position spelled out in the Rafiq Mercy's case and Thomas Daniel's case. In both the cases, because my case is covered by Rafiq Mercy, because the recovery was ordered in the year 2019.
Now, where is the order of recovery?
Lordship, they have not directly communicated any order of recovery, but with the affidavit in opposition, there is an internal communication. That is a page number. Running page number will be page 47. Lordship, this is the order dated 19/12/2018. On complete. Annexure 3. On completion of 30 years of service, number such and such Biren Malagar of this unit was sanctioned 3rd MSCP with effect from 11/11/2010 by Group Center CRPF Khodkoti by office order number such and such dated 21/11/2016. But punishment of withholding one increment without cumulative effect was awarded to the above individual White 164 BN such and such dated 16/9/2010. However, while sanctioning the 3rd MSCP, this order was not given effect in GC Khodkoti order quoted and sanctioned 3rd MSCP above individual with effect from 11/11/2010. But it should have been sanctioned with effect from 1/7/2012. Resultantly, his case was sent to this unit for issue of necessary amendment in the 3rd MSCP by GC Agartala by office order letter number such dated 28/11/2018. Accordingly, following amendments are hereby issued against his name as per details given below. So, as per the instruction contained in the individual granted 3rd MSCP with effect from 11/11/2010 in payment such and such. Now, this has been given to the with effect from 1/7/36/2012. Withholding of one increment with effect from such and such. So they have recovered the amount from myself, pensionary benefit, because I have retired.
When did you retire?
Lordship, 36/2019. This recovery was ordered within one year of my retirement. Just within the 1 year before my retirement. So that cannot be recovered from my salary or pensionary benefit. Because the Rafiq Mercy's case, this is one of the criteria when the recovery cannot be made.
What is this? Office order dated 17/1/2019.
17.
Where is that? Is it annexure 4? 17/1.
That order.
What is page 25? Page 23 is the translated copy, typed copy of page 25.
Yes, Lordship. Page 23 is the type copy of that page 25. That is 71/1/2019. That is the type copy of the 17/1 order.
So basically, your case is that your third MSAP has been cancelled.
Third the MSCP has been postponed from 2010 to 2012. And the recovery was that amount, excess amount paid in between that was recovered. I am against that recovery. That cannot be done.
No, show me that particulars. This page 23,
Yes, Lordship.
it just says third MSCP so and so
With cumulative.
cancelled due to withholding of one increment.
Yes, Lordship.
And where's the order by which your increment was withheld?
Lordship, that penalty order.
Yes.
That okay. Lordship, it is at page 16 annexure 2.
This withholding of increment was preceded by some proceeding.
Yes, Lordship.
Any
I'm not disputing that because it is of 2010. Lordship, that page 16 is a type copy. Then entire order is at page 17 to 19. So I am reading the para 6 of that is relevant.
So what is the date?
Lordship, it is
You're not given the date.
Lordship, even in the order, the date was not there. The order that was served upon me, but in the affidavit in opposition, they have stated.
16 September,
16/9,
616,
16 September 2010.
2010.
So pursuant to a DP, this order was passed.
Yes, Lord.
Withholding of one increment.
Yes, Lord.
Then what was the effect?
That as a result, my increment was postponed or without cumulative effect.
It was postponed from which
Yes.
year to which year?
Without cumulative effect, then they
From?
have stated that so third MSCB, I will be entitled to third MSCB, not with effect from
11/11,
yes, Lord.
2010.
No, initially I was from 11/11. As such, the date of grant of third MSCB was amended from 11/11/2010 to 1/7/2012. They have stated in page 28, running page 28 of the affidavit in opposition.
There is no formal order on that.
Lordship, formal order was not served upon me.
But where is the statement in your writ petition?
Lordship, I have stated.
Where?
The para 10 and para 9 also, that the petitioner begs to state that the deduction of recovery is made on account of the overpayment towards the MSCP by the respondent authority is highly illegal and unjustified. It is stated that the petitioner is entitled to third MSCP with effect from 11/11/2010. That is the date of completion of 30 years of regular service. It is stated that till 11/11/2010, the petitioner has received only one regular promotion, that is to the rank of head constable. As such, he is entitled to the third MSCP on completion of 30 years of regular service. Hence, cancellation of the third MSCP from 11/11/2010 by deferring the same till 1/7/2012 is illegal. Next para, Lordship. That the petitioner begs to state that the petitioner is entitled to MSCP with benefit with effect from 11/11/2010. It is stated that even if assuming but not admitting that the petitioner was mistakenly extended the benefit of third MSCP with effect from 11/11/2010 instead of 11/7/2010, then also the amount given to the petitioner due to such mistake on the part of the respondent cannot be recovered from his salary in view of the law laid down by the Honorable Apex Court in its decisions. In this regard, it is stated that even if any overpayment was made to the petitioner, same was not because of the misrepresentation or fraud on the part of the petitioner, but was due to the mistake on the part of the respondent. Hence, recoveries of the same at the fake end of his service is highly illegal. It is stated that the petitioner was a Group C employee and was having only 6 months of service left before superannuation at the time when the recovery was made. in pursuance to order dated 17/1/2019. Hence, the recovery was made made as a consequences of the order dated 17/1/2019 is highly illegal, and the amount recovered is liable to be returned to the petitioner.
How much is the amount recovered from you?
Lordship, 1 lakh something is there.
You're not aggrieved with the penalty.
Lordship,
You're not aggrieved with the penalty.
no, because
You are aggrieved only with the recovery.
recovery. Because at this stage, I cannot challenge the penalty that was imposed in the year 2010.
What does Rafiq Masih say?
Rafiq Masih says that it has dealt with the situation. Para 12, Lordship. Para,
Yes.
last part of the para,
Yes, within 1 year.
yes, Lordship. The
Sub-para.
recovery of the belonging to the employees class 3 and class 4 services, group 3. The recovery from the retired employees or employees who are due to retire within 1 year from the date of or the order of the recovery. Recovery from the employees when the excess amount has been paid for a period in excess of 5 years before the order issued. The recovery of the case, recovery in case where an employee was wrongfully been required to discharge duties of the higher post and has been paid accordingly. That is not my case.
So you're covered by which paragraph?
It is para 12, clause 1 and 2. And in the last part of the,
You belong to group C.
yes, Lordship. I'm just a head constable.
And you were due to retire within 6 months.
Yes, Lordship.
Yes, what do you say?
On the last occasion, this case was heard by Justice Methi. At that time, they have said that they do not have any objection regarding this recovery.
We have no dispute about the recovery portion, Lordship. We have recovered the money and it will cover, Rafiq Masih will cover this. But in second part, where he,
That is, I'm coming to the second part later. That is
What is-
regarding the next increment. That is next increment due to him.
Yes.
That has also been covered by the Supreme Court judgments are there. That if a person retired on 30th of June, then he will be entitled to the next increment which is due to him on the 1st of July. Initially, a Madras High Court has decided this matter and Supreme Court has affirmed this matter. And thereafter review affirmed, that was also dismissed.
What is that case?
Lordship, that is the case of P. Ayapurimilam versus the register on 15th of September 2017.
but this notification was issued on 14 October 2024.
Lordship, that is notification has affirmed what the Madras High Court has decided. The Madras High Court, their case is that I have retired from service in the year 2019, so I will not be entitled to the benefit of the notification that was issued in the year 2024. But this case was initially decided by the Madras High Court. Madras High Court has affirmed what has been stated in the rules only. It was decided on 15/9/2017, that is before my retirement. And it has stated in the para 7. The petitioner herein had completed 1 full year of service as on 30/6/2013, but the increment fell due on 1/7/2013, on which the date he was not in service. In view of the above judgment of this court, necessarily he has to be treated as having completed 1 year of 1 full year of service, though the date of increment falls on the next day of his retirement. Applying the said judgment of to the present case, the writ petition is allowed and the impugned order passed by the first respondent, the tribunal dated 21/3/2000 is quashed. The question shall be given one notional increment for the period from 1/7/2020 30/6/2013, as he has completed 1 full year of service, though his increment fell on due on 1/7/2013 for the purpose of pensionary benefit and not for any other purpose. So this was the judgment, and I have given the SLP against this judgment. This was the Madras High Court judgment. SLP I have given in the next page. It is there. I have plagiarized it. So SLP was dismissed. Thereafter, review was preferred. That was also dismissed by the Supreme Court. And as a consequence of that,
the department has come with a office memorandum, that also I have relied upon. It is the office memorandum of 2024, but that office memorandum is, it was issued on 14th of October 2024. That is only reaffirmed what has been stated in the judgment. What the judgment has affirmed, that has been clarified in this office memorandum. So I will be entitled for that. They are saying that as because this office memorandum is issued on 14th of October 2024, I will not be entitled to. That cannot be. Because I have retired from service on 30/6/2019, and my next increment was on 1/7/2019. And
What does this office memorandum say?
office memorandum says that entitlement regarding that,
As per the judgment of
yes,
Supreme Court.
as per the judgment of the Supreme Court, this office memorandum was issued.
Yes,
Uh,
it seems to be a covered case.
But office memorandum issued on 24. I am on that office memorandum issued on 14th October 2024, and he was retired on 2019.
This
Therefore,
office memorandum was issued with reference to the judgment that has been stated, and para 2 of the office memorandum is stated
Yes,
about the judgment.
Judgment was
basis of-
passed in 2017
Yes, Lord.
and affirmed by the apex court.
After that, this
Uh-huh.
office memorandum.
So
was-
it should apply.
But he was retired on 2019. so
Okay,
how
but
can this-
does this office memorandum say that it will apply prospectively?
No, that's it.
Then it refers to that judgment only. So under circumstance, I think he'll be entitled to.
Paragraph 7 of office memorandum is
Yes. Is examined under Honorable Supreme Court and so and so. And I don't think there should be any confusion about it.
So I will not be able to get the other benefits. Only the pension will be, as increment will be counted only for the pensionary purpose. That has been clarified in the judgment also. Supreme Court has subsequently clarified this. And as a result, this office memorandum has come. Before there was another office memorandum that they have annexed to the affidavit in opposition. There they have stated that there is a review pending. That review has gone, that review was dismissed. And thereafter this office memorandum has come.
Okay, so we'll dispose it off.
Yes, sir.
I'll record your objection. Hart, Mr.
SN Tamuli.
S.N.
Tamuli.
Tamuli, learned counsel for the petitioner,
My
and-
submission may be recorded.
and Miss
S. Borua.
S. Borova, learned CGC,
Yes, sir.
for the respondents. Stop considering the nature of grievances projected by the petitioner. The writ petition is taken up for disposal at this stage. Next para. It is the case of the petitioner that he was working as head constable in the CRPF, head constable.
Yes, Lord.
And on account of certain department that
Subsequently, this head constable has been redesignated as assistant sub inspector ASI in CRPF.
Okay, head
Because they
constable.
were merger of the post in CRPF.
head constable bracket subsequently redesignated as
Assistant sub inspector.
assistant sub inspector. Please read the sentence. Inquiry drawn against him. Which concluded against him he was imposed with a penalty of withholding one increment without cumulative effect. White office order dated 16/9/2010. Stop. In the meantime, the petitioner was entitled to be given the third modified assured carrier progression
Yes, Lord.
bracket MACP with effect from 11/11/2010. But in view of the penalty imposed upon him, the same has been postponed What is the date? Postponed
Yes, Lordship, it was postponed to
to
1/7/2012.
1/7/2012. And whatever benefit that he had received was therefore recovered from him.
Total amount recovered was 1,21,763. They have stated in their affidavit.
Amounting to rupees
1,21,763.
121,763. This was recovered as in terms of this annexure 4.
Yes, Lordship. The page 28 of the affidavit in opposition, they have
28 or 23?
Lordship, in running page number 28 and normal page number 3, they have stated
No, what is the date of the order?
36 to basic overpayment for a period of
Is it 19/12/2018?
Yes, Lordship.
19/12.
As the per GC or office order number. Lordship, this is order dated 17/11/2019. Accordingly, his pay was fixed, amended, granted third application, as per as such, the overpayment on the basis of the period was.
See.
They have not given the date, Lordship. Or 36 no, 2019, Lordship. Last. 36 2019.
That is your superannuation date. Why you are confusing the court? By which order you have this recovery was made?
Lordship.
Is it not 19/12/2018? Page 28,
Yes, Lordship.
middle of the page,
Yes, Lordship. Yes.
office order number so and so dated.
Yes, Lordship. That is the order 19/12/2018.
Please continue without full stop. In terms of the office order dated 19/12/2018. Now, the petitioner is aggrieved with such an action. Taken by the respondent authorities for recovery of the amount already paid to him, since the same is in gross violation of the settled principle of law laid down by the apex court in state of Punjab and others versus Rafiq Masi, reported in 2015 for SCC 334. Next para. The further grievance of the petitioner is that the petitioner is entitled to receive the increment admissible to him with effect from 1/7/2019, which otherwise has been denied to him on account of him having retired on 30/6/2019. Stop. Learned counsel for the petitioner submits that the admissible increment cannot be denied to the petitioner in view of the judgment rendered by the Madras High Court on 15/9/2017 in WP number 15732 of 2017, open bracket, P stop Ayam Perumal, spelling AYYAMPERUMAL versus registrar and three others, close bracket. Wherein it was held that the petitioner in that case had completed one full year service as on 30/6/2013, but the increment fell due on 1/7/2013, on which date he was not in service. Stop. Relying upon the earlier judgment passed by the same High Court, the High Court of Madras held that the petitioner has to be treated as having completed one full year of service, though the day of next increment falls, no, next, cancel the next, though the day of increment falls on the next day of his retirement. Stop. The said decision was put to challenge before the Apex Court Is it the same case? Just a minute.
Lordship,
Oh, yes.
it is in the same bunch I have given.
Same bunch.
Yes, Lordship. I have marked it as self-reproved. Arising out of it is written there.
By the Respondent Union of India by filing SLP C number 022008/2018. But the Apex Court dismissed the SLP. Full stop. Further review filed by the Union of India was also dismissed. Stop. Consequently, office memorandum dated 14/10/2024 was issued by the Government of India, Ministry of Personnel, Public Grievances and Pensions, Department of Personnel and Training. Incorporating the decision of the Apex Court, which upheld the decision of the Madras High Court insofar as grant of notional increment was concerned. Stop. The Learned Counsel therefore submits that the case of the petitioner being squarely covered, similar benefit should be given to him for calculating the increments entitled to him. Although he has already retired from service on 30/6/2019. Next para. Learned CJC, on the other hand, submits that since the office memorandum was issued only on 14/10/2024, while the petitioner retired from service on 30/6/2019, the same cannot cover his case for granting incremental benefits. Stop. Insofar as the issue of recovery is concerned, she submits that the law laid down by the Apex Court in Rafiq Masih, Supra, holds ground as on date. And therefore, she has no further submissions to be made in this regard. Next para, I have considered the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record, including the authorities relied upon. The Apex Court in Rafiq Masih, Supra, at paragraph number 12, had summarized the situations under which recoveries from the recoveries by the employers would not be permissible in law. So paragraph 12 bracket small Roman 1 speaks about recovery from employees belonging to class Roman 3 and class Roman 4 service, or group C and group D service. While paragraph 12 within bracket small Roman 2 speaks of recovery from retired employees or employees who are due to retire within 1 year of the order of recovery. Stop. Having regard to the facts projected by the petitioner in this case, which are not disputed, namely VIZ, the petitioner having retired on 30/6/2019. While the recovery having been made in terms of the order passed on 19/12/2018 would only go to show that the case of the petitioner is squarely covered by paragraph 12 bracket small Roman 1 and bracket small Roman 2 of Rafiq Mashi Supra. Stop. As such, the amount of rupees that I given, 1 lakh something, so recovered from the petitioner will have to be refunded by the respondent authorities. Stop. Insofar as the claim for grant of increment with effect from 1/7/2019 as per his entitlement, it is seen that the petitioner indeed retired on 30/6/2019. And in the case of P. Ayam Perumal Supra, it was held that despite the employee having retired, despite the increment falling due, I'll repeat again, despite the increment of the employee concerned falling due on the next day of his retirement, still the increment admissible will have to be given. Stop. As already noticed, the said decision of the Madras High Court has been upheld by the Apex Court and therefore has attained a finality. Stop. Although the learned CGC has raised an objection on the ground that the office memorandum has been issued much after the petitioner had retired from service, but the fact remains that the said office memorandum relates to the decision made by the Apex Court upholding the earlier decision made by the Madras High Court. Stop. Under the circumstance, this court is of the considered view that the benefit flowing out of the said decision of the Madras High Court, which in fact was decided on 15/9/2017, cannot be denied to the instant petitioner. Stop. Accordingly, on both counts, this court finds merit, and accordingly, the amount so deducted as stated herein above be returned to the petitioner, be refunded to the petitioner, and the respondents shall also grant the admissible increment to the petitioner after making appropriate calculation. Stop. Such an exercise be done as expeditiously as possible and preferably within the outer limit of 2 months, 3 months, 3 months from the date of receipt of certified copy of this order. With above observation and direction, the writ petition stands disposed of as allowed, no cost.
Much obliged.
Mr. Saikia, who are the petitioners?
My lord, petitioners,
Board members?
my lord,
Which board?
most of them are retired now.
From which board?
Board is governed by the government of Assam.
No, what board?
State Social Welfare Board, Lordship.
Social Welfare Board.
Board.
You're claiming pension?
My lord,
You're claiming pension?
we are not getting pension. We have.
You are claiming pension,
Pension.
but you are board members. Are you entitled to pension?
Yes, I will show their appointment letter.
Okay.
Lordship, the plea taken by them that they are not, in their affidavit they stated that the petitioners are not holding any sanction post. That is their plea. My lord, I will not take much time by your lordship.
Social Welfare Board.
Yes, Social Welfare Board.
It is constituted under what provision?
My lord, it is constituted by the government of India. My lord, I will draw your attention, lordship attentions. Social Welfare Board, my lord, the for the weaker section of people.
All right, but the question now would be whether it's a pensionable post.
Yes, lordship, I am pressing people. Lordship, can we see? At para 3, page 26 may be seen. Page 26. My lord, subject, extension of pensionary gratuity benefits to the employees of state boards. Sir, this is a letter issued from New Delhi, my lord. I am directed to say that the government has been considering for some time the question of extending the pensionary gratuity benefits to the employees of the state boards, and the government of India has written to all state governments as early as July 1978 to agree to the extension of such benefits. Since then, replies from various state governments have been received, in some cases agreeing to the proposal, and in some cases intimating that the question is under consideration. Some states territories have agreed to the proposal and to meet their 50% share of expenditure and have requested for release of the share of the Central Social Welfare Board. Consequently, para 2, it was earlier thought that a decision in the matter may be taken after all state union territories have consented in the proposal, but due to obvious delay and continuous denial of these benefits to the employees, the state board, it has resulted into hardship to the employees. Keeping in the above factors in view, this department has considered this matter in consultation with the integrated finance division of this department and have decided that the pensionary gratuity benefits may be extended with effect from 1/4/1979. Lordship, page 27, madam. To the state board employees in cases where the state government concerned has also agreed to the extension of such benefits and also to share 50% expenditure in accordance with the agreed pattern of expenditure. In cases where the CPF benefit is already filed, the employee may be given an option, should be exercised and be treated final within the period of 6 months of the introduction of the pensionary gratuity benefits. Last, my lord, the government of Punjab, Chandigarh, Goa, Daman, and we have so far agreed to the extension of these benefits to the employees of state boards, and as such, the Central Social Welfare Board may take necessary action to release their 50% expenditure to the concerned departments. This issue with the concurrence of the integrated finance department, letter number so and so. This is matter issued by the Department of Social Welfare Board, Shasti Bhavan, New Delhi, Government of India, madam. Now, Lordship, most important issue is that they are raised in the affidavit that we are not government employee. Lordship condition. That case.
There is no Department of Social Welfare Board.
Yes.
This is Department of Social Welfare, Government of India.
Yeah, because my lord, the visual purpose for the four section of the people, this board was constituted. 4 section and 4 women section.
So the petitioners retired as what?
Some of them as UDA, some of them as LDA, and they were promoted from LDA to UDA. I have annexed those documents.
Group C post.
And most of them were promoted.
Group C post.
To the
LDA will be what?
The upper division from the LDA to the upper UDA.
They are categorized as what? Group A, Group B, Group C? What is the category? Group C, I think. Grade 3, Group C, like that. Anyway.
Initially, they were opened as LDA, lower division clerk. Then they were promoted to the post of upper division clerk.
In the board. Then they retired on superannuation. But since it's a board, so there was no pensionary benefit.
I'm placing
You
it
have
on
come
the-
for that
Yes,
pensionary benefit.
They are not considering what you kindly see the page C0.
This communication is way back in 1979.
Here it was continued.
Huh?
The government of India is continuing. Page C0, my lord.
Continuing means?
That the in the whole of India,
Hmm.
more than 23 number of states, the states have paid the 50% and the government of India has paid the 50%.
50%. But
That's it.
see, you just read.
Negligence of the government, they did not comply with the order of the government of India. 50% already government of India has sanctioned. And the remaining 50% should have been sanctioned by the state of Assam. My lord, page C0 may be seen, my lord.
So this is a joint venture.
My lord, page, yes, lordship, correct.
Government of India will give 50%, state will give 50%. But state also has to agree,
State
na?
of Assam is silent.
The state also has to agree. Automatically, it doesn't apply like that. The state also has to agree. Okay, we'll give 50, they will give 50.
Lordship, now kindly see page C0. Because they are only plea that we are not government employee. Page C0, my lord, 30 may be kindly seen. Rules governing composition and functions of the state social welfare advisory board. Functions, my lord, rules, my lord, these are the rules. May be called the rules of the state social welfare board. My lord, board means the state social welfare board. Central board means the central social welfare board. Chairperson means the chairperson of the state social welfare board. Government means the state government territory. So government means government of state and union territory. Now, my lord, kindly see composition of the state board. Number Roman 1. The board shall consist of such members that will be decided by the Central Social Welfare Board. Central Social Welfare Board money the government of India, my lord.
No, that's
My lord,
okay.
kindly see, my lord, below Roman
This
5
is for the state.
for the state and
Oh, this is Central Social Welfare Board.
Central Social Welfare Board, my lord, these are the rules made by the Central Social Welfare Board of New Delhi
Made for whom?
for this state board, State Social Welfare Board. The composition of the purpose of rules governing composition and function of the State Social Welfare Board. This is made by the Central Social Welfare Board, New Delhi. And the Central Social Welfare Board is the government of India. I will place it, my lord. Now, my lord, kindly see page 31. In the top, my lord, before the expiry of the tenure of the incumbent of an incumbent chairperson of the state welfare state board, the state government should send a panel of 3 numbers along with biodata of the individuals to the central board for the letters concurrence for the appointment of the chairperson If no nomination for appointment proposal for extension of tenure is received from the state till the date of expiry of the term of the chairperson, the state board, the government, till the date of expiry of the term of the chairperson, the state board, the central government welfare board shall take a decision for extending the time or making fresh appointment. State government will not make an interim administrative arrangement unilaterally. So it is the government of India, that is the central board, my lord. Now, you will also Roman 6 and 6. Very important. Sorry, D may be seen. In case the board is not reconstituted after expiry of its term due to the one reason or the other, Central Social Welfare Board will appoint an officer in charge through an administrative order as a stopgap arrangement to discharge the duties of the chairperson till a regular chairperson is appointed. So chairperson is appointed by the government of Assam. Now, Roman 6, half of the non-official members, excluding the chairperson, shall be nominated by the Central Social Welfare Board and the other half by the state government. So it is composition made by the central government as well as by the state government, my lord. Half. Now, B may be seen, my lord.
See, to that aspect, Mr. Saikia, see, to that aspect, I don't think there's any argument. State will make the recommendation, the board members are this composition is there. But when it comes to regarding the pension,
Yes,
is there any provision provided in these rules?
I will come to that. I will come.
I think that is the main thing.
I will come. I will place it, my lord. Lordship, only that page, my lord, Lordship will kindly see page 34. Page 34. 34, my lord.
Powers of the board.
The board shall remain current accounts, shall maintain current accounts, saving bank account or any other account with the State Bank of India or with any nationalized bank in case the state government instructions are contrary to this prior proposal of the Central Social Welfare Board should be obtained to open account in banks other than nationalized banks. All receipts of the board shall be paid into the board's bank account. The account of the board will be operated by the following. Number 1, chairperson, my lord, that I am placing. Number 2, treasurer. Number 3, secretary. Now, next column, it will be mandatory for the secretary to be one of the signatories. In case secretary is not available, chairperson of state board, which the prior approval of Central Social Welfare Board authorize a suitable officer in this place. So it is repeatedly stated that Central Social Welfare Board, this state social welfare board will govern by the central under the central social welfare board. Page 35, my lord, kindly see. This is very important. Roman 8, my lord. Roman 8. The employees of the state board will be governed by the state government rules in terms of the service condition. The state will also follow the state government rules in case of other financial and everything matter. This is the subject matter. My lord, that that we will be governed by the state rules, state government rules. So we are state employees. Lordship. Now, whether we are, Lordship, another point I am placing you, Lordship. Government employee. Government employee. Yes. Next one. Next one.
Para 19.
Government means that government is alone.
Page 30, share version.
Board is constituted for a particular period of time, isn't it?
My lord, page Annexure 9, Annexure 9 to this. Lordship, I will place it. Annexure 9, affidavit, no? Now, that they stated that we are not government employee, we have filed an affidavit in reply. The page number to what? Annexure 9 to Annexure 9 to. Hello, Hanasano? Affidavit. Affidavit. Yes. My lord, we have filed an affidavit in reply. That is very important. Page 110 of my affidavit. Affidavit in reply, my lord. Because their only ground is that we are not government. We are not government employee and posts were not sanctioned. In their affidavit, they stated that their posts were not sanctioned. So, my lord, our page 110 may be kindly seen. Affidavit, we have filed an affidavit in reply, my lord. Page 110, Lordship. This is a letter issued by the Deputy Director to the Secretary. My lord, kindly see. I am directed to refer State Board's letter and so, my lord, letter demand details of the sanction post number is 21. My lord has got it, Roman 1. Detail of sanction post is 21. Lordship, the next page, Lordship will see page number 111, table 1. These are the posts, my lord, sanction post 21. Number of posts approved as per norms of 1978. Secretary 1, Accountant 1, CS, Senior Assistant 1, PA to the chairperson is 1, Assistant UDC 6, LDC 4, Divers 3, then my lord, Dafrish 1, Peon 2, Watchman 1. So total is 21. These are the posts we are holding. And these posts are sanction posts made by the government of Assam. And this letter is issued from the Central Social Board, New Delhi, page 110. So we are holding the sanction post, my lord, and we have, Lordship, we have, my lord, page 112 may be kindly seen. Letter 6 December 2003. This is the government of Assam, Pension and Public Grievance Department, my lord, kindly see. In continuation of this department letter, OM number so and so, it is reiterated that the said OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. The focus is on 20 years of continuous service. After rendering 20 years of service, if the government servant is superannuated or incapacitated or dead, is not root point. Any confusion in this regard is against the spirit of the office memorandum referred to above. It is therefore clarified that the pensionary benefit as contemplated in the above office memorandum shall be admissible to a government servant who died after rendering 20 years of continuous service. Other term condition for eligibility of pension shall remain the same. So here, my lord, even if somebody died, Lordship now will kindly see the page 113. Again, this letter is issued by the Central Social Welfare Board from New Delhi. Lordship kindly see release of C installment up to 75% fund under the State Board establishment for the year 2020, 2021. My lord, I am reading in English. Please find and enclose a statement showing the amount credited in your state. So, credited in your state board, accounts on 3121 in respect of state board establishment. This is released against the approved BE for the year of 2020-21 after adjusting first and second advance released on 31/3/20. Next, Lordship will kindly see the letter amount released at page 115. Lordship, kindly see, my lord. Column number, in all the states, they have as because the government of Assam is not releasing 50%, so Assam is shown as 0. And others are getting. This is discrimination, Lordship, on the part of the government of Assam. Because the government of India is sanctioning the amount, but this government of Assam has not come forward. So Lordship will kindly see another now. Lordship. Lordship, we have annexed the list at, in the requisition that page, well, for a while, page, my lord, 31, maybe 39 may be seen. Page 39 of the requisition, Lordship, very important letter. That is the notification, my lord. Page 39, my lord. Notification dated 27 March 2017, my lord. In view of the expiry of the term of existing members of the Assam State Social Welfare Board, with effect from 29/15, the Governor of Assam is pleased to reconstitute the Assam State Social Welfare Board in exercise of the powers conferred under Article 3, Subclause 4 of the State Rules governing the composition and function of the State Social Welfare Board for a period of 3 years with immediate effect and until further order. So my lord will kindly see the name of the members are given, and bottom all the financial matter including bank transaction will be operated by the chairperson and the member secretary jointly. So chairperson Lordship has found that chairperson is appointed by the central government. That is the, and the letter issued by my lord additional chief secretary to the government of Assam. Social Welfare Department, Dishpur. So the department, this Social Welfare Department, my lord, is under the government of Assam, as per the directions of the Central Welfare Board. Consequently, she, the
Mr. Saikia,
my lord,
this will take some time, you see.
my lord.
Why don't we post this matter on some hearing date instead? We'll have this matter on some hearing date.
My lord, Lordship may keep it as a powder because I want to do the case before Lordship, because some of them already left for heaven without pension. They get actually, my lord, I have brought the judgment of the Honorable High Court and Supreme Court. That you Lordship is well conversant that the pension must be given to the government servant. Under Rule 31 of the pension rule, my lord, 3 conditions are to be fulfilled, and we have fulfilled all the 3 conditions, my lord. Lordship may kindly keep it as part hard.
No, part hard will be difficult.
Part hard. I have today's admission. Maybe keep that.
Not part hard. We'll listen on hearing date.
Next week on admission stage.
Tuesday or Thursday, on
My
hearing date. There are less cases on hearing dates, so I think we can spend more time.
Tuesday, my lord. Tuesday will be
Tuesday.
hearing date or Thursday. Tuesday will be hearing date. Tuesday.
It will not be part hard because it cannot be part hard. The bench is available only till Saturday. This is the problem.
I think you Lordship will be here
Till Saturday.
because an early disposal necessary because my lord.
So that's why I'm
out of
fixing
this
it on the hearing date.
Out of these petitioners, my lord, some of them have already left.
All right.
Even the Thermakolita, he himself has left for heaven, and on petition, his wife became a part, my lord, petitioner one.
The projected case of the petitioners will require a detailed hearing, and therefore let the matter be listed on Tuesday. 8th of April
10th.
for admission hearing.
Can be on 10th, Lordship.
No, 10th will be too late. The coming week will be, will be a holiday, so in case it spills over.
On
Eight.
next
Tuesday.
Tuesday, my lord.
Next Tuesday. It's a hearing date, so for admission hearing, okay?
Okay, Lordship.
Oblige, my lord.
Oblige your Lordship.
In this matter, I am looking for the respondents, my lord. In fact, my lord, I oversight the matter, my lord. Somehow I left out, my lord.
Union of India.
Not prepared myself, my lord. I'm trained for an accommodation. The pleadings is completed, my lord. So can it be on the next week, Tuesday, and on a hearing day, my lord? So it could be concluded, my lord.
Invalidation
My lord.
from CRPF.
My lord.
What is the ground?
Here, my lord, the invalidation procedure that has been followed.
It's a penalty.
It's not a
Penalty.
penalty, my lord. They found me medically unfit. due to
Medically
alcohol-
unfit. Okay.
Alcohol dependency syndrome.
Hmm.
Now, the process that was required to be followed, my appeal part was rejected only on one ground that I gave the certificate from the district officer, district medical officer, whereas their rules say it should be a civil surgeon. Our case is that they are of the same rank and I should have been given the opportunity of an appeal to find out whether I still remain a dependent or not. That appeal having not been given to me is one ground where I would,
What do you get once you're invalidated?
my lord, next to nothing with the NPS now on. Earlier, invalidation would give me the service benefits for that period that I had served. But with the NPS coming on, he being a person from 2007, he goes out with only what he had accumulated
Contributed.
in the NPS and nothing else. The entire family goes down the drain.
Okay, once accommodation.
No difference, my lord. He told me. that-
Tuesday forward.
No issues. My lord.
As paid for by the learned CGC and not objected to by the other side. List this matter for admission on Tuesday next. Give the date, please.
Registered to so reflect my name UK Goswami in the cause list. So I oversight the matter, my lord. Sorry, my lord. Affidavit has been filed by myself, my lord.
Registry shall reflect the name of Mr. UK Goswami, CGC,
My lord.
in the cost list.
Highly obliged, my lord.
My lord, on the next week, I may have some difficulty. Could it be on immediately on the reopening, my lord?
On a hearing day, so that it.
Any hearing day, my lord.
Tell me, when do you want? 22nd or 24th?
22nd would do, my lord.
And change the date. List on 22nd.
Highly obliged.
I'm obliged.
Yes. Area salaries.
Area salary, current
How much?
salary also.
How much?
From
Has
your
it been quantified?
From 1/6/2011.
Ah.
I am.
Lordship may have a look at the last order, Lordship.
I am receiving the lump sum amount, but not salary orders.
Lordship, there is clear separation of material fact,
No,
Lordship, in the
nothing is there.
petition, Lordship.
I am stated that not salary. I am receiving lump sum amount from 60. Because my salary is 1,47,000. As on date.
So you were granted to take time to get instructions.
Page 29 of my petition, your lordship will clear from the.
Mr. Upamane, any instructions?
Lordship, thereafter
What
I have-
exactly was given to him?
Lordship, it is the salary, Lordship, but that instruction, Lordship, has not been provided to me, Lordship, because Lordship, this matter came up in the year 2024, Lordship. Thereafter, I am yet to receive instruction, Lordship. I have to get the updated instruction, but in my affidavit in opposition, Lordship, I have clearly stated that he is continuously getting his salary since 2016.
Hmm.
So
When? 2016?
from 1/6/2000, Lordship,
16 January?
Lordship, 1/6.
16/1/2016 from.
Salary is
Not
normally,
Lump sum amount, 65,000.
salary means
My salary is, monthly salary is 1,46,000.
normally it's from the beginning of the month, isn't it? Why the 16/1?
Lordship,
Only
because-
half salary?
No,
The
Lordship, because he has
16 one,
joined,
2016, because that time I am promoted.
he was promoted and he has joined this Lahual PHC, Lordship, on that day. So thereafter, he is getting continuous salary,
Not
Lordship.
salary it is. It is my lump sum amount because.
And
if you
Lordship,
not
to
get
that,
response-
Lordship, he has filed a affidavit in reply wherein he has annexed the pay slip, Lordship, that has been drawing by the
No,
petitioner, Lordship,
lump sum.
since 2016, Lordship. Lordship, this fact was known to him at the time of filing of the instant writ petition, Lordship, but he did not annex these documents in the writ petition. Neither did he make any statement, Lordship, in the writ petition. I have gone through the writ petition, Lordship. There is no such statement. And moreover, at Lordship, at para 4 and 12, para 11 of this writ petition, he has clearly stated that he has not received any money, Lordship, since 2011, which is
Salary.
not a fact, Lordship.
I am saying about salary. Also. Your Worship, page 29 of our petition, it's a
Lordship,
letter of Joint Directorate is clear.
So in terms of the last court's order, would you like to take instructions
Yes,
then?
Lordship, I'll get the instruction whether it is lump sum amount or it's a salary, Lordship, which he has been receiving since 2000.
How much time then?
Lordship, let it come after a week, Lordship. Immediately after vacation, Lordship.
As prayed for by Mr. D. Upamanya, Learned Standing Council, Health Department. Further 2 weeks' time is granted to obtain instructions in terms of the last court's order dated 31/5/2024. List again on 23rd
Yes, Lordship.
of April.
Highly obliged.
Obviously.
My lord, there is a direction, last occasion to give the reply to affidavit opposition, my lord. Here, my lord, the case is like petitioners once regularized, but after that they reverted back, the regularization is gone. After that, there is a proposal to consider, and there is also my lord, to the government says that that should be considered, it is not considered. That is why petitioner approached this honorable court. In the meantime, one of the petitioner got retired. So, my lord, we have filed an additional affidavit because they have submitted a case says that this is covered. So there is a distinguishable point. So, my lord Justice Sam has directed me that you produce some documents so we can produce a distinguishable. To that effect, they have to file a reply. They have not filed a reply. So our case is that from documents we can show an additional affidavit that our name was forwarded and this is finance department concurrence of finance department, my lord. In additional affidavit page 56. So now they said that no, you are not regularized because you are in deputation. Our case is that we are transferred by the parent department to serve for a board. This is a part of the component of these parent boards. After that 2011, we are reverted back with this post. But problem arises that once regularized, they said no, you are in original status, work status. After that, corrective measures is taken. Department has returned to government, but that was not acted upon. That is why we filed this case. So, my lord, kindly see page 33. Before that, my lord, our initial appointment is 8890, my lord. This
Okay, an affidavit in possession not filed, isn't it?
not filed,
My lord,
So they have
if I
to
may
respond.
just point one thing, my lord,
Ah.
page 35 of the writ petition. Page 35.
Yes.
There is a serial number 5, my lord. That person's name is Joy Narayan Sharma. And my lord, he is that petitioner from that covered case, my lord. And subsequently dismissed by the division bench also. Same issue, my lord.
35.
35.
There is no
No,
35.
page 35. Page 35, my lord.
Serial number?
Serial number 5.
Yes. What
That is-
about him?
That is the same petitioner, my lord. I have just placed the judgment before your lordship. He's that same petitioner. His case was dismissed first by single judge, my lord, then again by division.
My lord,
Same person, ma'am. And at serial number 6 is the current petitioner.
Robin Chandra Roy.
Lordship.
then my lord Ashok Kumar Roy, my lord, this honorable court has given him all the benefits, my lord. Because, my lord, finance department concurrence, that is the main points. They should be come forward with that. Probably among them some finance concurrence was not there. But in my case, my lord, they should come forward with this affidavit, my lord, because my lord, page 33 says that our regularization is not a anti-formalities, it is by departmental selection committee as well as concurrence of finance, my lord. And they have not disclosed about our status. That is why we want them to file an affidavit. Yes. They only showed that judgment, but in our case, mayor, maybe our case is considered. But it's page 33.
What was the case of Joy?
Same, my lord. He was also deputed to sewerage board,
Hmm.
and there also, my lord, they were placing reliance on a order saying that he's regularized by the board.
Hmm.
There, my lord, the honorable court has held that that was not a valid order of regularization. And lordship, in addition, that it is a case covered by Upen Das, where it has already been held that muster roll workers cannot be given pensionary benefits.
My lord, our case is that we are transferred by parent department to their components.
That
board,
is why, my lord, they,
And their case is the deputation, my lord.
Same.
Let them file affidavit because distinguishable points are there. We should get opportunity to respond to this. My lord, our appointment, my lord, kindly see page 33. Here it is says that in pursuant of government letter dated UDD, that is a departmental letter, my lord, and recommendation by department selection committee, my lord. Based upon that, our regulation is done. But government has regularized, not board. They say that board cannot regularize this master roll. Because our joining date is prior to 1493. That is the cutoff date where government has taken a policy decision to regularize the master roll workers.
Alright.
Otherwise also, my lord, this court, honorable court has given the relief in, I have annexed this, my lord. It is not that because of this page 41, my lord. So they should come, why we should not, why this is same, why we should, why the distinguishable points is not, that should come this affidavit, my lord. And more particularly, this government letter.
It's
my
up to
lord,
them. If they want to file, they'll file. If they don't want to file, they'll.
Yes. My lord.
otherwise, my lord, by the judgment, it is very much covered, my lord. And
They
in
omnibus-
affidavit, my lord, we can file it.
Yes,
being on
that should
record,
be
my lord.
File your affidavit. Take your stand.
Yes.
Although, Mr. Your good name.
MJ Bodo, MJ Bodo.
I bought it, my lord.
My MJ Bodo, my lord.
Although Mr. I. Bor Thakur, learned counsel for the
PH, lord.
PHE department, submits that the case of the petitioner is squarely covered by the division bench judgment of this court in State of Assam versus Upen Das, reported in 2017 for GLR 493. He submits that he may be given some time to obtain instructions and to file counter affidavit. So Mr. M.J. Borwa, learned counsel for the petitioners, also submits that the respondent should take a stand in the matter so that the petitioners can have a chance to
Respond.
respond to
One-
it. In
may
view of
I do, my
above,
lord? One thing on page 56 of my.
2 weeks,
additional
3
time.
weeks,
3 weeks.
3 weeks time is granted.
My lord, may I pray one point?
What
Page
you want to pray?
56, my lord. This is the case, my lord. In their case, financial concurrence was not there, but here, my lord, I have annexed one documents through
It's okay,
RTI.
you save your argument, let
Yes.
them file. On one hand, you're saying let them file and you're arguing also.
Say,
List again after 3 weeks.
well, oblige. Make legal laws.
May please, my lord. My lord, I'm on behalf of respondent number 3 for the board, my lord. For the board.
Which board?
Assam Urban Water Sewerage Board. Actually, my lord, our instruction that we received is not complete one. We need some more time, at least that the matter will come up after vacation. In the meanwhile, we can obtain some instruction.
How much time?
Immediately after vacation, any date may be fixed for that.
Since he is taking time.
It's a case of compassionate appointment, not regular basis.
Yes, they should have been lordship appointed in regular post, but they have been appointed in Khalasi workers post, which is not permissible as per the lordship policy of compassion appointment.
Very simple case, Lordship. And board has also, Lordship, taken their resolution and decision by a board that.
On the
they should
prayer
be-
of the learned counsel for the respondent number 3, Mr.
K. Vishwakarma,
K. Biswakarma,
on behalf of Mr. S.P. Chaudhary.
who appears on behalf of Mr.
S.P. Chaudhary.
S.B. Chaudhary. Standing counsel,
Yes, ma'am.
which board?
Assam Urban Water Sewerage Board.
Standing counsel, Assam Urban Water Sewerage Board. Further 3 weeks' time is granted to file counter affidavit.
Fix it, data, difficult.
This, the matter again on 28th of April,
Lodge,
I'm obliged.
2025.
obliged, Lodge.
Yes,
Withdrew the lordship.
Mr. Hawk.
Occasion, my lord, yes, my lord. Last occasion, my lord, Learned counsel for the center, my lord.
You are saying that you are entitled to second MSCP.
Yes, my lord, I am.
Sanction has to be given to second MSCP,
Yes, sir.
but you have not been given.
Yes, ma'am. This is my case, ma'am.
Hmm.
Only
Why?
It's not entitled because of, he is not fulfilling the benchmark. Earlier, it was good to benchmark APR grade mark is good, but in 2016, it is upgraded to very good. That is the benchmark for all, but in 2016, his benchmark is good. That is what is
no,
taking it.
what do you mean by benchmark? In benchmark in what?
This is annual performance appraisal report. The
I see.
benchmark is
APRs.
good, yes, APR.
Depending on their benchmark in the APR, they will be getting or not getting the MSCP. I see. This is under which
This is CRPF.
CRPF? You have filed an affidavit?
It is complete lodge.
We'll list it on a hearing date. Let it be considered because it'll take some time.
It will take time.
Next Tuesday, my lord. Tuesday next.
Come up after vacation. Next week, maybe motion with lordship. Possibly.
Yes, probably.
Date may
yes.
can be. Any motion? Yeah.
Parties are represented by the respective councils and they submit that pleadings are complete and the matter may be taken up for admission hearing. In view of above, and as played for is this matter,
On 22nd April.
22nd, some matter already fixed lordship. Can it be on 6th of May lordship?
6th of May, all right,
Much obliged.
6th of May,
Okay.
2025.
Hey, please, you.
Hmm.
This matter, your lordship, basically, the petitioners are coming before your lordship on the ground. That they were appointed, but they were not given their adequate post according to the qualification, which they are ought to have been given. This was basically, these were the employees, were the erstwhile employees of a private sector, which was a government sector. And ultimately, also that has closed down. So there, some employees have taken particular compensation and left. Some employees are absorbed by the government. These are the employees who were absorbed by the government. And then in the process, there was a meeting between the association as well as the government where they have decided that they will appoint them according to the education.
You are relying upon some meeting minutes.
What's it?
You are relying upon some meeting minutes.
Yes, it was between the government and that. Then there was a.
Can it be enforced, meeting minutes?
That the government has given their, they have issued the notification, and the notification they have stated that we are absorbing these employees on the basis of the qualification which they have. Then they given this in most of the employees, a few of the employees, they have not been given. These petitioners were not given that. Lordship will kindly, if your lordship is hearing the matter, then your lordship will kindly initially start with the.
No, hearing will be difficult, Mr. Manan, today.
Yes.
Now, one thing was required to be done.
Yes.
Rejoinder was to be filed.
No, we have filed them.
You have filed.
They have filed the reply, affidavit. We have also filed the reply.
When did you file reply?
Reply, if you could have filed this,
May
reply to
29.
affidavit in reply was filed on
Because the
29 May.
office note does not indicate anything.
29th day of May, 2024 itself, the reply.
Reply you filed.
Apply to our affidavit.
Yes. Hmm? No, only affidavit has been filed by 1, 2, and 9. 4 to 7, 5 to 7.
But you say reply is filed, but the reply is not here.
One.
Your Lordship, we have also filed our affidavit. On the consent of three.
Opposition is there, but where is the reply?
Reply from Chennai. Affidavit and reply আমি ফাইল করেছি। No, 4 to 7 ঠিক আছে। There were 2 affidavits filed. One is by 1, 2, and 9.
Reply,
The
isn't it?
other by 3. Then we
Yes.
filed.
8 also filed, Lordship.
We filed the
35/24. On 30 May 2024, you have filed. Reply against the
reply-
affidavit filed by the respondents 1, 2, and 9, and also 3. You have filed, yes, but somehow.
এইটো আছে মোৰ তাত নাই দেখোন ক'ত। চাই ল'ব লাগে। Anyways, your lordship, I think কোনটো কোনটো reply দিয়ে পাতিম। One do না গোটেইকেইটা। নহ'ব।
Then who remains? 4 to 7.
7 I'm not.
That is the thing. 4 to 7. Anyone for 4 to 7? Have you filed? One? When?
Copy নাই দিম। Copy দিছে 4 to 7. এটা নাই বুলি ক'লে ফাইল কৰা নাই। আমি কি কি ফাইল কৰিছে সেইটো কোৱা।
I think we'll have to check up. It's not there.
কোন দুটা কোৱা।
Would you like to check it up then?
Reply to.
As office note says that there is no affidavit from 4 to 7.
All of them. Yes, respondents have filed the affidavit. They have practically all have filed. We have filed a reply, and I think only one.
But there's an office note.
That will most probably cover the.
There's an office note of 28/3 which says that respondents 4 to 7 have not filed their counter affidavit.
Okay.
You just check up. I don't find it also.
আমাক দিছে তাতে নাই ডিজাইন তো হ'ব পাৰে এটা আমাৰ এফিডেভিট কিটা দেখোন মোক অকল দুটা দিছে কপি মই কেনেকে জানিম তো মোক কি কপি দিছে
4 to 7.
নাই দিছে আৰু তো মোক বেলেগ এফিডেভিট
Then what about that office note of 28/3? Is not correct or what?
সেইটো রিপ্লাই ফাইল এটা পেছনে গিয়ে এফিডেভিট
Let us-
এটা মোক দিছে
ইয়াত কিবা লিখা আছে নহয়?
1, 2, and 9
ভুল হৈছে।
1, 2, and 9 আমি ফাইল কৰিছো আৰু আমি 3 ফাইল কৰিছো 3 এফিডেভিট ইন রিপ্লাই এফিডেভিট ইন
Okay, yes.
এফিডেভিট ইন অপোজিশন
Hmm.
এটা মোক গোটেইকেইটা দি দিবা এতিয়া আমি অকল 4 to 7 ফাইল কৰা
Parties are represented by the respective councils and they submit that the pleadings are complete. To stop, the office note dated 28/3/2025 appears to have been wrongly entered in view of the fact that the respondent numbers 4 to 7 have already filed their counter affidavit on 27/2/2025. Stop as paid for by the parties, list the matter for admission hearing
after the view vacations
after the view
any
vacation.
date that may be lordship may
You want a date?
yes lordship that is better
Mr. Kalita, you're there also?
I'm fine with, like, after view vacation is fine with me. Lord.
You are
I'm
there for
I'm
which
there,
res-
Lord. I'm for responding for 1 to 1,
1, 2, and 9
1, 2, and 9.
they filed the affidavit
We have filed an affidavit, they have filed a reply
we have
also.
also filed the reply against that
29th of April?
lordship
29, Lordship, we will give it.
April
First week of
First of May.
First week of May, any date, Lordship.
6th of May then.
Lordship.
Hmm.
Much of.
Yes.
In this case, this to emanates from the cancellation of the transfer order. Actually, we are appointed, the government has taken a policy that person who are interested, they can apply for the online transfer of their posting from one district to another district, my lord. That was published. In response to that, we applied for transfer, my lord. A transfer order was issued, my lord. But just a few days thereafter, the transfer order cancelled abruptly. So this is a national, this is the fact. The government was not denied it, my lord, that
Where are you? You're in the original place.
I am in the original.
You have
place.
not moved. You have not moved.
Because of cancellation, my lord.
Okay.
So this is why before my lord, that they filed an affidavit, my lord, they in the affidavit, they admitted the facts. Only the things in the first.
What is the reason for cancellation?
Nothing, there is no reason. And I have a judgment of your lordship, what my lord is held, that in the case of modification or cancellation of order or overwhelming public interest must be shown. Otherwise, that is not tenable. I just know, I have a judgment, my lord. It's Itanagar bench, my lord has passed it in para 16, my lord. Lordship is there.
What do you say? Huh?
Hearing-
You have filed?
Yes. my lord.
File or
In
affidavit,
affidavit,
in
my
all
lord,
the
paragraph
cases,
4 and 5.
for hearing may not, a date may be fixed on hearing date.
There is nothing, my lord, they've admitted it.
Otherwise, it appears to be a short matter. eh?
Yes, very short.
But time constraint is there. Have it next week if you want to.
Lordship.
Next week?
Next week.
Don't agree readily if you're not ready.
That's after Bihu.
After Bihu. Okay. Parties, the parties are represented by their respective councils and they submit that the pleadings are complete and the matter be posted for admission hearing after the ensuing Bihu vacation. To stop in view of above and as paid for. Yes.
So for my lord, the first item is concerned, my lord, item 21.
Mm.
Well, that may be fixed and a fixed date after view vacation because now private respondent is involved in that matter, my lord. But
You want it to be detached?
22.
You want it to be segregated?
Segregates better, my lord, because in 22, 22 private respondent there, 21 there is no private respondent. So it's a very short matter, lordship may taken up and dispose of, my lord. in the
When do you want it? Give me
Around.
Yes.
Representing the private respondent.
I'm for the 22 member item,
Mm.
but my senior is out of station.
It's all right. We have not taken up the matter today. We are fixing it after the vacation. You want at a particular date?
Lordship.
When?
Convenient to
1st
file
of
on-
May? 1st of May?
Lordship and.
Thursday.
Yes.
Please the matter on 1st of May. As paid for by the learned counsel for the petitioner, these matters be segregated
Yes, ma'am.
and listed separately on that day.
On that.
He'll be listed on that day, but separately.
My lord. Deeply obliged. Interim order is there, my lord, that may be.
In which case?
Both the case, my lord.
Acha, interim order passed earlier shall continue till the next date of listing.
Obliged, lord.
May please your lordships. Last occasion, he took time to file.
Lordship, in this case, Lordship, my affidavit is ready, Lordship. There is a technical problem, Lordship, I am facing, Lordship. Lordship, the commissioner and secretary is not there in our department now, Lordship. Secretary is there, secretary is not a party here, Lordship.
I filed the case in the year 2023. Now they have sent as a secretary, not commissioner. My respondent number 1 is the state of Assam represented by the commissioner and secretary. So there is a secretary is there, so he can.
Commissioner, secretary, different post, Lordship. Secretary is the secretary to the Governor of Assam is different post, Lordship. So my secretary.
Earlier it was commissioner and secretary, now it is secretary. Since I have made party to the earlier, my lord, the case is in the year 2023. Now he stated that secretary won't be able to put their signature to file the affidavit. What wrong, my lord? Because I have stated that state of Assam represented by the commissioner and secretary. It is secretary. Secretary is already there, my lord. Now he said that I would like to make party again, my lord. Why should I? Because secretary is there. Am I correct, lordships?
I don't know.
Problem is there, Lordship. Secretary and.
These are
I
basically
couldn't understand what he submits.
Commissioner
before
and
your
secretary.
lordship.
commissioner and secretary,
Only
principal secretary.
Commissioner and secretary are two different post, Lordship. Two different category of post, Lordship. So commissioner and secretary is.
I don't have any idea.
there,
regarding all
See,
this.
secretary is there, commissioner is there,
Lordship.
commissioner and secretary is there,
Yes.
Additional
principal secretary is there,
Yes. Lordship.
additional chief secretary is there. I mean, it runs into a lot of numbers.
The time.
now,
there
Lordship,
is a-
Now, should there be any difficulty in, I think
Lordship, a secretary, how can he say that I am responding to one, Lordship?
Why not? Because I have made party,
If
state
he-
of Assam represented by the commissioner and secretary. He can represent.
My.
No,
Since
somebody
secretary
can,
is there.
swear that on his behalf,
Secretary
authorized by
will
so and
be
so like that
swearing.
also.
On behalf of.
Additional
Lordship,
secretary will be swearing.
On behalf of commissioner and secretary,
Hmm,
Lordship.
hmm.
Yes.
Secretary has to swear.
Any,
Because.
not only
otherwise there is
secretary,
no government.
I think under secretary and above can swear on behalf of the government.
Lordship, pass. Lordship, necessary order, I will.
See, the nomenclature starts as the state of Assam.
Yes.
That is important.
Yes.
Represented by whoever it may be.
Yes.
Under secretary and above can represent. Main thing is the state of Assam. So you can always say that state of Assam represented by so and so,
So and so.
and somebody can swear it. Where is that harm,
I'll
Mr.
talk.
Upadhyay? Had it been directly the commissioner and secretary, I understand.
Yes.
that I'm not the person, but
Yes.
this is the state of Assam.
Yes.
Represented by somebody. So anybody can represent under secretary, deputy secretary, joint secretary, additional secretary, secretary, commissioner and secretary, principal secretary, anybody.
Then, Lordship, it has to be filed by the deputy secretary then. In
Ah,
this case, Lordship.
yes, somebody can swear that.
Lord.
There's no issue in that.
Lord.
How much time? 1 week.
1 week. Lord.
A week's time is granted, Mr. N. Upadhyay, Lanet State Council,
Date
to
long.
file the counter affidavit.
After 1 week.
List again after a week.
Date-
Anyway, it will come after vacation only.
Okay.
Okay.
Oblige your
Oblige.
lordship.
None appears for the petitioner when the matter is called. List the matter again. After a week.
Made his lordship.
Mm.
Lordship, what happened in this case, I had filed an reply affidavit on 29/2024.
Okay.
So I found some clerical mistakes. So on 28/3, I have filed an application for correction in my reply affidavit. So the typographical mistakes can be corrected and I will file a fresh amended affidavit in reply. So this is not tagged today. So that matter can it be taken by next week so that this order may be passed and I can file my amended
You file IA.
yes, for correction of the
IA.
yes,
you
serial
have-
number,
Do you have the number?
yes, 3963/25.
Please write down. Learned counsel for the petitioner submits that since there is some typographical error in the reply affidavit filed by the petitioner has filed an application seeking correction of the same white SL number, serial number 3963 of 2025. Stop. However, since the said application is not tagged along with the writ petition. She prays that the same may be done and listed, and the case be listed again after a week. All right.
Can I, a date, can I avail a date before vacation so that I can do that?
In view of above, this matter again. On today's what, second, isn't it?
Before, any date before 10th or 11th?
On 9th of April 2024, 25. A registry to verify and connect the IA file said to have been filed by the petitioner with the writ petition. All right.
Much obliged.
May I please?
Yes.
In this case, Lord, the authority has not allowed me to resume my services, Lord, only because of that, your Lordship, the pendency of the criminal petition.
You were
criminal
arrested.
Case, Lordship.
You were
And,
arrested.
Yes, Lordship, I was.
You are on
arrested,
bail now.
Lordship, and released on bail, Lordship.
Release on bail.
Undergoing 56 days judicial custody, Lordship. Accordingly, I have filed representation before the authority with a prayer to allow me to resume my services. But the state authority has not disposed of my simple representation. Accordingly, Honorable Court has passed this order. Kindly be perused, Lordship. Order dated 13/5/2024, Lordship. Kindly be perused this order, Lordship. Wherein Lordship directed to the Chief Executive Officer, Lordship, to pass an appropriate order on basis of the simple representation filed by the petitioner itself, and if failing, Lordship, wherein directed to the Commissioner and Secretary, Lordship, to take initiative in respect of the said, Lordship. But subsequently, Lordship, in pendency of this, the simple representation, Lordship, the authority has let me know that I was suspended by this order dated 28/5/2024, Lordship. That is the suspension order issued by the District Commissioner. It may be placed before the court by the council itself, Lordship, respondent council, that I was suspended.
Then
Lordship, but in the suspension order, Lordship, itself reflected that in the first column, that is 28/5/2024, and the subsequent, Lordship, hearing signature of the District Commissioner, that is 28/1/2024. Be that it may, Lordship, but Lordship, another, Lordship, one suspension order issued by the Commissioner and Secretary itself, that is 24/7/2024. Now I am in puzzle, Lordship, that the two number of order has been passed, Lordship, wherein I was suspended, Lordship.
where is the other one?
And the other one is that, your Lordship.
No.
24/7/2024. Now I am in puzzle, Lordship. That what I will challenge. Even, Lordship, the Honorable Court order, Lordship, previous order has remained unimpacted, Lordship. That is the 13/5/2024.
The authority is different, isn't it? One is by the district commissioner and one is by the
Commissioner and
commissioner, Panchayat.
But your Lordship, this is not the review order, Lordship. Earlier occasion, Lordship, I was suspended and no disciplinary proceeding, no appointing authority. Inquiry officer has been appointed, no so-called notice has been issued to me, Lordship. Now, on what order I will challenge, Lordship? Either District Commissioner or by the Commissioner and Secretary, Lordship. That is a contradictory issue, Lordship. If I challenge the district order passed by the District Commissioner, then, Lordship, another order has been remained forced, Lordship. So clarification may be required, Lordship.
You are under whose direct control?
Lordship,
Commissioner Panchayat or
Commissioner and Secretary, Panchayat Department.
Okay.
Under the Lakhimpur Gaon Panchayat.
District Commissioner has no role?
District Commissioner, Lakhimpur District.
No, who is the immediate authority under whom you serve?
Appointing authority is the Commissioner and Secretary, Panchayat Department.
Panchayat. And what is the role of District Commissioner then?
District Commissioner, Lakhimpur District.
What is the role? Insofar as this thing is concerned, what do you call, what is the name, what is the post that you're holding? You are holding?
Inside Secretary of Prabha Gaon Panchayat, Lordship.
Prabha Gaon
Actually,
Panchayat.
tax collector, Lordship, my original post, Lordship.
Yes, anybody appearing? Mr. Dhar, you are there? Some clarifications required. Which suspension order should be applicable?
My lord, we have already filed an affidavit to the effect. Affidavit filed by the respondent number 4.
No, question is,
Yes, my lord.
there are two suspension orders. One by District Commissioner, one by Panchayat and Rural Development Commissioner.
My lord.
So why there are two suspension orders?
My lord, in this writ petition, we will have to see, my lord, to the context in this writ petition, what he has challenged, my lord. If he is agreed by the other order, he has to challenge it before lordship, my lord. He just cannot, I am not aware, my lord, unless it is brought on record. How can I respond, my lord? In this writ petition,
My present leave petition has been filed only because of that authority has not allowed me to resume my services. Because of that, Lordship, present leave petition has been filed. But in the meantime, during the pendency of this case, Lordship, Honorable Court directed order dated 13/5/2024, Lordship, wherein it clearly indicated that the inability of the Chief Executive Officer were not able to pass the appropriate order on basis of the representation, Lordship. Therefore, Honorable Court directed to the Commissioner and Secretary to take
my lord,
initiative, Lordship. If required,
my lord will
disciplinary
just come to this cost title, my
proceeding
lord.
may be enforced,
What he
Lord.
is seeking. Petitioner was neither suspended nor denied for
No,
his
at the
service.
time, Lordship, I was
So,
neither
my lord,
suspended.
let him challenge whatever documents he has. This is, my lord, this is not a Gram Panchayat, my lord, that he will just pass a letter to his lordship, my lord. Whatever it is, he has to brought on record. Unless he brings that document on record, how can I respond to this, my lord?
Lordship, two number of suspension order had been passed by the two different authority, Lordship.
Whatever, my lord,
What I will say is,
unless that is challenged by.
So, Lordship, this Honorable Court order has remained unenforced, Lordship. That is 13/5/2024, Lordship. Kindly where is this order, Lordship? So, status report may be called for from the from the Commissioner and Secretary, Lordship. Initial stage, Lordship, when I approached before the authority, Lordship, authority is saying that, no, your post is temporary, so you are not, we are not allow you to resume my services. Being agreed, the present lead petition has been filed. Now the entire and fact has been come before upon me, Lordship. Passing only because this order, Lordship, now authority has taken responsibility. In respect of the same, Lordship, one another case that is 3/2/2024, Lordship.
Where is your representation? Where is your representation? Two 11/2023.
Two 11/2020. NXIE page number 31, Your Honor.
This has not been disposed of.
Yes, Lord.
Not disposed of.
not dispose of land.
What is your stand, Mr. Dhar, regarding this?
My lord, page number, my lord.
This page 31, annexure E.
My lord, that is PNRD, yes, to my lord. This is the chief executive officer, Jilla Parishad, my lord.
Yes.
So they will respond, my lord.
Who is you are there?
So, because of PNID department, some time will be given to obtain instruction.
On behalf of
For the PNID.
S. Datta. PNRD. Where is he? He's not come today.
For some personal difficulties, yes, he did leave.
We'll list again on Monday. Ask him to get the instruction by then.
It can be on Wednesday.
Why?
Some time may be given, Lordship, in case.
Time is there. Thursday, Friday, Saturday is there. This is regarding the disposal of the representation. That's all we want to know. Okay, please write the code. This code, white order dated 13/5/2024 had directed the Chief Executive Officer, Lakhimpur Zilla Parishad, North Lakhimpur, bracket respondent number 5 to dispose of the representation filed by the petitioner on 2/11/2023, bracket annexure E. But according to the learned counsel for the petitioner, the same has not been done till date. And instead, two separate orders dated 28/5/2024 and 24/7/2024 has been issued by the District Commissioner, North Lakhimpur, and the Commissioner, Panchayat and Rural Development, respectively, suspending him from service. From the date of the arrest of the petitioner, that is 4/7/2023. So since the learned counsel for the PNRD department is not available today, and as prayed on his behalf, list this matter again on Wednesday next. Give the date, Wednesday. 9th April 2025, on which date the status of the appeal, status of the representation should be informed to the court. These two suspension, you'll have to think about it.
No.
Mr. Dhar is also right. If you have to challenge, you challenge. You incorporate both.
I have another one I have already challenged and pending before this
Ah.
court, Lordship, 3/2/2024 law.
It's listed today.
Not listed today, so Lordship, kindly be take with this lead petition, Lordship, that is 3/2/2024 Lordship. One another case, Lordship, wherein I have challenged order passed by the district commissioner looking for.
As paid for by the learned counsel for the petitioner, list this case along with WPC number
3/2/2024.
3213
Yes,
of 2024.
yes.
Hmm.
Deeply.
Sometime,
Chief, please pass over the matter for the date.
not pass over. We see, we'll grant you the other side sometime. There's no counter affidavit. Mr. Dhar is there. What is this?
Yes, Lordship, one of my colleague is there, Lordship, so.
DLC, SLC, that, what is this? Compassion appointment?
Compassionate appointment.
Hmm.
More again, we have got that series.
Sorry?
My lord, a compassionate series is going on, my lord.
Uh-huh.
More against this before court number 4.
Series?
Series.
On what issue?
My lord, there is an OM of 19/8/2024, wherein the government has come up with a notification that post 2017 July, the government will not give any further those who have
Instead, compassionate pension.
only pension,
Hmm.
no appointments. my
That
lord.
has been challenged.
That is under challenge, my lord. There is a
So
series.
this is also related to that. Is it connected to that?
At the end of the day, my lord,
Post, you said which date?
2017, my lord, July 2017. No, but this is the 24 matter. This cannot be, my lord.
It cannot be.
Cannot be because 19/8, 89 is the date of the OM, my lord. That is under challenge. 89/24. So this is prior to this. This is a altogether writ petition, my lord. If they want to argue, I can always argue the matter, my lord. But I think senior is not there.
Yes, sir. Yes, my lord.
Otherwise, I am ready.
Without filing affidavit?
My lord, I will go on law.
Huh?
I will go on the law and the OM. That is the holding the field, my lord. We have following the Debarbrata Tiwari, my lord, that Supreme Court judgment, my lord, we have come up with the OM, my lord, that we will not further. And as of today, there is no SLC, no DLC. We cannot consider. That is
No,
what.
there's a cutoff date, you see. No more DLC, SLC will come from a particular date. And if it happens to be prior to that, then?
My lord, after July 2017, my lord, from 2017 to 2024, it's a span of 7 years. So we follow that, my lord, principle laid down in Debarbrata Tiwari case, that immediacy is lost. Since immediacy is lost, it will not be considered. That is under challenge.
Immediacy.
Immediacy.
If you can survive for such a long time, the immediacy is not there. That's what he says. So when do we list this matter then?
After Bihu.
Huh?
After Bihu.
After Bihu, as paid for by the Learned Counsel for the petitioner, list this matter is in after the Bihu vacation.
Lords.
Same order? Or who's here?
May I please, your lordship, this Kabat case, your lordship, judgment scale up regarding Upen Das, and it is relating to Kaziranga National Park, lordship.
Well,
Kabat case.
where they working? As what?
As what your lordship order is there regarding scale of pay in Upen Das case, lordship, by referring.
No, Upendas we know, but present petitioners.
Present petitioners are Mastarul casual workers. Their name have been forwarded before the authority, but that has not been considered.
Master workers where?
Master workers, lordship, in the Kaziranga National Park.
Kaziranga National Park.
Yes, lordship. Your lordship will find
And Kaziranga National Park is under whose control?
Forest Department.
Forest Department.
Forest Department. That is also.
Mr. Chalia.
Lordship, I am appearing for the Finance Department. Here, Lordship, they have made a categorical statement that the Forest Department has forwarded for consideration, Lordship. So, and as per the Upendas judgment, Lordship, it was passed in 2017, 10 years prior. People who have been appointed 10 years prior to that, that is since 2005, we have been paying them the minimum of the pay scale. Here, my learned friend has not mentioned anywhere since what date he has from the petitioners are casual workers working in Kaziranga for last more than 10 years. Lordship, they have not specified. So if they have been, Lordship, if they have not specified, that has to be verified by the authorities in the Forest Department to see whether they come under the minimum of the pay scale. Because Lordship, Finance Department has also introduced the sunset clause, Lordship, where
sunset clause.
Yes, Lordship.
What is
where for regularization, Lordship, we had asked all the departments, all the muster roll workers, all the casual workers, we had informed all the departments to give a list of names who they have appointed in the last 10 years as per Upenda's judgment, Lordship, because since that was passed in 2017, we time and again we have forwarded and we have asked for the names, because otherwise it's a endless task, Lordship. So regarding that, maybe in that, as per that step, Forest Department has confirmed, and whether or not they have forwarded those names to the Finance Department, because concurrence will be required, Lordship. So on the basis of these facts, Lordship, I cannot say like whether or not my learned friend is entitled to it from the facts.
Kindly see.
No, that of course the authority will decide. We are also not going into that such a minute detail that
Yes, Lordship.
examine how far he, whether he is on, he has got
Because
that.
all the casual, the state has
Now,
all.
simple thing is that if it can be disposed of in line with Upendas
Upon verification,
for
Lordship.
consideration by the authorities in line with the,
Yes.
a paragraph was mentioned
Yes,
there,
the paragraph 22.
22 of
23,
the
and from Upendas.
Upendas.
But Lordship, if I would, if Lordship may fix it on
Here-
Friday, Lordship, because
Here is also, their names has also been forwarded. List is there, my learned friend disputing when they are working, the date of engagement is there.
Where?
That Lordship, kindly see, page 44,
44.
list forwarded.
Forwarded by whom?
Forwarded by DFO Lordship, list of 25 numbers of casual employee list.
How many petitioners are here?
Here are the 24 petitioners.
24. So
Two
all of
list-
them are here.
Yes, two lists forwarded. One list is dated 22/7/2020. Another list is 8/8/2023. That is page 44 and 46. The name of the petitioners are already appeared.
So
Now-
this was in the year
yes,
2023.
Lordship, and it has been addressed to the principal chief conservator of forest, chief wildlife. These are authorities that will come under the forest, and why they have not, whether they have sent it to the finance department for concurrence, Lordship, or whether it's still lying with them, Lordship, that is not known. And if it has been not sent to the finance, the reasons for not sending it, maybe there has been some shortfall in the service record, Lordship, that needs to be verified.
Forest is not represented today.
Forest, Lordship, the authorities in the forest department are not there. So Lordship may fix it on Friday, Lordship. I will inform them, and at least their stand will be required, Lordship.
Let them come. We'll ask them also.
Friday at 2 p.m.
So that,
At 2
Lordship,
p.m.
Friday.
You want time also?
Lordship, without Lordship. If Lordship-
You are a busy man now.
No. Lordship, why, I'm sorry for that, but why
I will inform the
stated,
authorities
Lordship.
in the forest department, Lordship. They'll be present on the next date.
Since it's a Kabad case,
Lordship,
if
will-
time not permits, that's why I have.
Please write, going by the communication dated 22/7/2023, bracket annexure 8.
And 8/8/2022.
The presence of the standing council forest department is required. Since the council is not available today, list this matter on Friday.
Lordship,
Give the date.
Friday.
Remaining matters, you'll get a date. I'll rise.
Next item, Lordship, item 34, Lordship. I am for the petitioner. There is an interim, Lordship, that may require to be continued.
Court
Item
must,
30,
you
interim
will
order is there.
kindly indicate to the court master if there's an interim, then we'll
Regarding
continue.
interim order is there. Item 34.
That's what I'm
there is an
saying.
Interim, Lordship. That's why required to be continued, Lordship.
Take for all the matters, all.
Short date item 34. Why to date to fix for how is the problem? Friday on March Friday. On 7th.